there.
All right. You're going to be live in just a few minutes. You should see on the top left here that you're live. I'm going to dart.
Well, I think we're now live on YouTube. I'm Dan Biles on the Kansas Supreme Court. I'm the non-voting member of the nominating commission for the 25th Judicial District. We're live on YouTube. We have a majority of the members of the commission present on this, and I think we're ready for our first applicant to come in. I'll tell the commission members that I was going to use the same format that we've done in the past by asking the applicant to, there's Rob, to make a brief initial statement as to why they've applied for this position, and then turn it loose to you all, and you just ask your questions until we're done. So any questions about that part of the process? If not, let's go ahead and let's bring in our first applicant, who will be Mr. Velez.
I will bring Mr. Velez in.
Good morning.
Good morning, everyone.
We have a majority of the members of the commission present on this YouTube connection, and I thought we'd use the same format that you're used to already from your previous interview, and just have you give a brief introduction as to why you're interested in the position of district judge, why you think you might be good at it, and then we'll just open it up to questions and go until we're finished.
All right. The question of why I am interested in the position is that, if I'm being honest, it feels like a natural progression that one goes from who's a law-trained magistrate to seek out promotion as time goes by. I also believe I would be good at it for the same reasons that I believe that I am a good magistrate. I am deliberative. I'm a little self-effacing as I try to address every individual concern that comes before me with the same rigor and analysis. I like to think I'm a fairly smart individual who can articulate himself well and come to the right decisions when I have to. And well, I think I've given the speech 3 times to this group in the last 5 years, and I don't believe much has changed since the last time I did it it would have been May 2019. So I'm more interested in what the commission has to ask of me and what I can explain about what the few changes that have changed on the application, or have heard about what I've been doing out here in Syracuse, or seen what I've been doing. So that kind of concludes my opening statement.
Thank you, Chris. Since you and I work together every day, we've developed good relationship, I think. I know you have impressed me in many ways, but what have you done wrong, reflecting back, whether it be in Garden or here or as you visit other places? Of course, I haven't recognized anything you did wrong, but there's bound to be something. So fill us in, and how do you see yourself growing, if you have? Maybe you didn't make a mistake.
Oh, that would, I can have a bit of an ego, but it takes a truly large ego to say you've made no mistakes. Well, I would say the biggest mistake that I made was when I first came on the bench. I went into my assigned duties with both feet, and I had requested that I be sworn in on a Friday, I had requested that I be sworn in on a Friday, and then after that, I was going to start hearing cases on the following Monday. And the idea behind that was with the way I work and with the way I know my own work ethic is that if I didn't go and hit the ground running, it was going to be hard to spool up and get used to normal judicial duties. Unfortunately, one of the byproducts of that was that I went feet first into a traffic docket that, well, it was very full. It was very full. It had been touched by probably 5 judges in 5 weeks. And with the way the Finney County traffic docket was through COVID, it was the judge who imposed order on that. And so it was very badly run, probably for 8 weeks. I just came in and I jumped in with both feet and I sank. I sank to the bottom, and it took me a while to get my head back above water, trying to just get things done efficiently, get them done the way that I wanted to, and get them done in a decent manner. And I struggled at times. I can have a very black temper. I can have a short fuse, and I was unhappy with myself that, one, I couldn't get control of the traffic docket was part of the issue. When I get frustrated, it sometimes bleeds through, and I, on several occasions, I know it bled through with both staff and with counsel and with defendants. And I have perhaps overcorrected ever since then. I try to keep that temper of mine on a very short leash. Again, I don't always succeed, but that is why Rob, you've seen me. I apologize over every little thing I do in court, because I am always afraid that temper is going to break out. And it's also why I try to coordinate and plan out as much as I can on the back end, because if I know I have a plan, I can deal with almost anything. And if I can foresee it, I can make sure that if there is a screw up, I've got an idea of how to fix it. So as far as how I've grown from those first days of flailing, it has been that ultimately things get done in that courtroom because the judge imposes order on it, and the judge has a lot of power to impose order on the docket. And if I want something, if I've got a concern, I just need to put in the time to try to address it beforehand, so that I never have to worry about it when there are people in the courtroom. And that is my preferred method of dealing with problems of that sort, is try to science it out behind the scenes before we've got anybody present, before we've got all the problems that associate when you get groups of human beings talking and interacting. Try to figure out all the problems you can before then, so that you can focus just on what's in front of you by the time you actually are in the courtroom on the bench, perhaps with a live mic on the record, and with defendants, so that you can also explain to defendants what's going on. Because that's another big part of it is defendants need to be made aware of what's going on. They're just as entitled to know what's going on as people with lawyers. And I'm making an assumption that defendants don't have attorneys, but most of them that I have dealt with have been self-represented for at least the first time they show up in front of me. So that's my operator. That when I say defendant, I mean a self-represented litigant. So they have a right to know just as much as people who have an attorney, and it's still the court's job to make them aware of that too. So that's also why I'm big on trying to science things out behind the scenes, so that I can just go in and focus on what's in front of me that day, and not things that we potentially could have addressed beforehand.
Justice Miles, I just wanted to advise you and Shelby that Mr. Lindner is here with us at the Schultz Law Office.
Thank you. I saw him walk in and behind the mask. All right, next question.
CJ, this is Gene Gady. It seems to me you're a pretty good fit where you're at. Do you see a benefit to the entire judicial district to change that situation?
Well, Gene, that's a bit of an unfair question, because if I answer honestly, then I'm going to be drummed out of here for not having a reason for taking the position. And if I am not candorous with the commission and toot my own horn, then that I'm somehow indispensable at a district level rather than over here, then I'm violating one of the basic tenets of what you expect from me, in that I need to tell you guys, I need to be blunt and frank with you guys. in answer to that is I think I would be an asset at every level. At every level, I will be honest. I hemmed and hawed a bit when considering applying for this position because when I thought about the potential candidates, it was hard for me to come up with reasons for why I would be the best candidate for this position. Is that I'd hoped to marinate on the bench for 5 years before having to consider applying for district judge or considering promotion. And there are people who have far more experience than I am and who probably are almost certainly better candidates. But I still do bring the same strengths that I bring to my courtroom in Syracuse. I would bring them to whatever case I was assigned in Garden. And I think those strengths with regard to my intelligence, my analytical abilities, my willingness to just put in as much time as the case needs, I think those would serve the district just as well or even better than they do out here, where I have 400-ish cases a year that are primarily small offenses. Some days it feels like half my cases are misdemeanor pot possession cases. Applying those abilities to more significant cases across the district or to Finney County could produce as good or better results. So to try to circle back, does that answer your question, Gene? It's hard for me to provide a unique reason why I think I would be better suited to serve the whole district than just Hamilton County. And I would agree that what we have going on out in Hamilton County is a pretty good gig for everyone involved at this point. But I think the things that because we've had a sea change out here since I came on the bench, and some of that, and a fair amount of that is COVID. But COVID has provided me with an excuse to do stuff that I wanted to do anyway. It allowed me to do it in a year as far as remaking our processes and how the courtroom is run, when it would have taken me 4 or 5 conventionally, because I started talking about wanting to do virtual hearings or make use of them, make use of an audio and of an AV cart. October of 2019, we had some cases where they were first needed. So I think that the skills and abilities and drives that have allowed me to do things well out in Hamilton County could be used to do the exact same thing at the district court level, at the district judge level, rather.
Who's next?
CJ, this is Zach Schultz. I think that the area that you would handle as a district judge is quite a bit broader than what you've done as a magistrate. And from what I understand is from what you did in practice before going to the bench, have there things that you've done over the last couple of years to broaden those horizons or to prepare for handling some of those issues that you would face as a district judge?
Well, to address the issue of the breadth of my experience, a fair amount of what I did in private practice would be what is handled by a district judge. I did a fair amount of Chapter 60 civil work in private practice. I divorced with 60% of my practice in private practice. The big hole in my practice was I didn't do criminal at all. And that is what I have done primarily through the last 2 years of being a magistrate. And I would say, what have I done over the last couple of years to broaden my horizons in regards to my legal experience? I've done criminal every day. I've learned something new about criminal law and traffic law every day for the last 2 years. So that has been, I would say, is what I've been doing to broaden my horizons, was just doing my day job. And it has been not a concern of mine, but I do try to keep fresh on things that I used to do. I don't get a chance to do divorces anymore. Just simple nature of the beast. And I do get to do the occasional child support enforcement, and I get to do some PFA and PFS stuff. So in answer to your question, to I would say my breadth of experience, the place that I have a hole now, the hole in my experience after being a magistrate for 2 years is I still have a hole on the felony post arraignment side. So felony trials, and I've never done a jury trial, which is a major concern of mine. Were I to become a district judge, that I would have to spend a significant amount of time just teaching. I'd have to learn. And I would have to go watch every jury trial that I could and talk with as many people as I could, try to learn how to conduct one, to learn both sides of it. The closest I've been to a jury trial, we had a few misdemeanor traffic matters that were looking to go to jury trial when COVID hit, and then with how the district decided to handle the COVID startup, the traffic docket was consolidated with the other Finney County dockets with Judge Woods. So that took away the ability for me to conduct to perhaps conduct a jury trial. So that would be the major hole in my knowledge I would have to fill, would be with regard to felony jury trial stuff. And that is one of those things that you can only really learn it by being around it and by doing it. Has been my observation of the process, especially with how most jury trials don't happen because they settle out. It's hard to put a pin in something and say, I want to go watch this start to finish, when everyone will show up day of jury selection beginning, and it'll settle before that process starts. So, but I certainly would have a great deal that I would have to learn as a district judge, above and beyond what I've already learned, the significant amounts I've learned in the past couple of years.
CJ, as a magistrate in Hamilton County, you've undoubtedly had to review and sign search warrants. What is your philosophy when reviewing those? What's the standard that you're looking for?
Well, that's not an open-ended question at all, Lucy. All right, I suppose the place where one has to begin with a search warrant and reviewing it is, what are they looking for to begin with? What are the alleged crimes that they're looking for, and what is the scope of the places and items to be searched? I am generally of the opinion that with the way our system is set up, it is the officer's job to present their case to me as far as establishing probable cause for particular crimes to justify the search warrant. It's not my job to go on a fishing expedition in the affidavit looking for a crime for which there's probable cause. So I tend to be of the opinion that they're going to come in with a search warrant that says, we believe defendant A has committed crimes B and C, and there's going to be an affidavit attached that says, whatever PC exists for B and C. And if I don't find B and C, then that's where my evaluation stops. I'm not going to look for a crime D that is not alleged within the four corners of the search warrant, but I, based on my training and experience and reading between the lines, think I see it. I tend to be, I think at least, I'm a strict constructionist on scope of items to be searched and seized. The purpose of a search warrant is to be narrowly construed. And so I have, on a few occasions where we've had search warrants, I've had officers come in and say they have someone who meth possession, and they want a blanket right to seize guns, any gun that they find, without regard to its legality or its actual use in the crime. And within the four corners of the affidavit, it doesn't allege anything about a gun at all, anything or violence from the individual. I bounce those because there's a constitutional right to gun possession. And just because someone is committing a crime of meth possession without something more significant, for example, that would make the gun a firearm, a threat to officer safety, or a part of the underlying crime, they're not going to get permission to seize guns, for example. So I think our system requires that search warrants be strictly and narrowly construed, and I try I try to do that. I will admit I've signed some fairly broad ones, but that is because back in July of last year, we had a homicide out here where we probably did 40 some odd search warrants in the span of about a month. And there was a lot of depth charging on Facebook where they would get a lead on trying to find an absconded defendant, and that it was a reference to someone's Facebook or to some geolocating data. And I did sign those search warrants, and ultimately they didn't find the guys. They're still believed to be in Mexico, I believe. But I have had some of those that have been a little on the broad side, but they were within the context of what was being looked for was appropriate, or so I thought.
What is your philosophy on no-knock warrants?
Well, I've never had to deal with a no-knock warrant, so I'm speaking purely in hypotheticals, but the purpose of a no-knock warrant is that it is an exceptional warrant that is to be granted for the protection of officer safety in extraordinary or unusual circumstances where notice would cause undue peril. And so I would believe that my standards would be that you have to have something more than we think there's a gun in the house. You have to have you would have to have something there that would make it extraordinary or constitute a clear and present danger to officer safety to warrant a no-knock warrant above and beyond, as in most cases, a conventional warrant service should be sufficient.
Any other questions?
Thank you.
Well, are we ready to wrap this up? But Magistrate Velez, why don't you, if you like, take a couple of minutes here to wrap up, and then we'll excuse you to go on to your appointment.
All right. Trying to think about how to open and close today, I kept circling back to a quote I read last year from a new biography by Andrew Roberts about Winston Churchill called Walking with Destiny, in which a tale is regaled from 1905, in which Eddie Marsh, a member of the Foreign Service, was asked to become Churchill's private secretary. He approached Pamela Plowden, who was a former romantic interest of Churchill, asking about whether he should take the job, because he was concerned that Churchill might have been the smartest man he ever met, but that he was truculent and overbearing. And Ms. Plowden replied that one sees all of Churchill's faults the first time you meet him, and you spend the rest of your lifetime learning of his virtues. That quote has often resonated with me because I see a lot of myself in that. I see someone who is probably too smart for his own good, who can be a little pig-headed, a little foul-tempered, a little foul-mouthed at times, who can come across as too self-assured and too uncaring about the opinions of others. But that I also like to think that if you can survive the first impression, that I am someone who has many virtues that at least partially offset my faults, and that this is a process, and that I hope over the last 5 years of meeting with this commission that my virtues have become a little clearer every time, and that at least with the attorneys, that ever since going on the bench, my virtues have become a little clearer after first impressions. So I'd like to thank everybody for your time this morning, and hope you guys have a great day.
Thank you very much, CJ. Appreciate you.
Thanks,
Thank
CJ.
you.
Thank you.
I'm out.
Okay, Shelby,
Yes.
I I just want to, so we've got 30 minutes before the next interview. And I'm not sure how this works versus the way my court channel operates, but can we just mute our microphones and stand down for 30 minutes, or do we need to do anything different?
No, I think that's just what you guys would do if you want your video off or on, and just mute yourself, and we'll reconvene right about 10 o'clock.
All right, all that means is we just don't jump off the Zoom session here. We just pause for a minute and we'll reconvene a little before 10. Any questions? All right, we'll take a break.
See, I press that to mute.
Come in. Yeah, I'm still on, we're just kind of in between.
Oh, cool. Good, then we'll do some vitals real quick. You had any prospects yet?
Yeah,
What you want?
no, not yet.
How are you?
Oh, okay.
Justice Biles, I spent the last half hour looking for the room with the donuts.
Well, what we know for sure is that John is probably there.
You know, I came to work to hop on this morning and my computer was updating. And I, for the life of me, don't know how to stop that. Deb, do you know, aren't you like still computer guru?
I forgot it all, Rob.
Oh, man.
If you don't use it, you lose it.
Okay.
Why don't you? I did. No. I did shower this morning.
Ralph, how you doing?
I am good. And you?
Good. Did your sundown probation expire?
No, it got extended.
Wow.
Yeah.
I did say Ralph. Who is that elderly man from Syracuse talking?
I'm not talking anymore, John.
Oh.
I'm trying to find the mute button for you and I can't do it.
You know, the nice thing about this technology is that we can do it from here.
The puppet master.
Justice Bob, this is Tom Walker. Have Shelby or somebody cue me back in.
See, that's exactly what was going on in my office when I was trying to get on.
Breaking.
Yeah, yeah.
What's he need to sign out and sign back in, you think?
I think he just needs to turn his video on. He's on, we can hear him.
Okay.
Turn my video on. Start video.
Yes.
It says I cannot start video because the host has stopped it.
I have the same problem, Shelley. Tim Cohart.
It may be that while we were in the break, they didn't want you on YouTube. So can we fix that on our end?
Yeah.
Oh, I got mine. It said start my video. Got it.
Now,
Good
what?
luck. Good luck, Tim.
There I got it. Technology is wonderful.
Yeah, if it works.
Isn't it?
And Ann, are you back on where you can hear us? And
Yes, I can.
great. Well, is Miss Cant in our waiting room?
It appears she is. I don't have a name on there. There's a number, but we'll see when we enter her. Are we ready for her?
Everybody okay to get
I
started?
think so.
Great.
Okay, I'll bring her in.
I'm glad it's raining today, so I've got an excuse to be wearing a hat. Is this just gonna happen nowhere? It's raining. I was surprised this morning.
They're saying like we're supposed to like yeah.
Miss Kate, are you on?
I am. Can you see me? Can you hear me?
Can't see you yet.
Life is good.
You can't see me. I can see you. Hold on.
Start your video. There
Okay.
you go.
All right. Start my video. Okay. You can see me now?
Yeah.
Okay, good. All right.
Well, we'll call the nominating commission meeting back into order.
Okay.
Here, 10:02. Ms. Gant, I'm Dan Biles. I'm on the Kansas Supreme Court, and I'm a non-voting
Okay.
member of the commission.
Okay.
My job just basically to convene and in the interview when the time expires or when we're done. Our typical format here is to ask each applicant to introduce themselves through a little opening statement.
Okay.
Explain why you're interested in this job and why you think you might be good at it. And then we'll open it up for questions. And then if you want an opportunity at the end, we'll let you
Okay.
wrap up.
Okay.
So with that, you can get started.
Okay. All right. Good morning, everyone. Thank you for the opportunity to interview and to come before you for the potential judgeship in the 25th district. I'm just going to sort of start with a catchy phrase. You know, we're in an unusual time with the pandemic, and as we know, we have to use PPE. So I'm going to use the PPE, but I'm going to change it to PPF. As part of my opening, and PPF meaning an outstanding past, an outstanding present, and outstanding future. And as far as my past goes, I've been in the legal profession for almost 25 years. I went to Duke University, obtained my CPA, and then went to Georgetown Law. I do have 3 state bars. I have a wide, varied path. And excelled in many different areas of the law, many of the areas which the county state judge would be overseeing. And I think that my exemplary past makes me a great candidate and great selection for the judgeship. In my present, I have been a judge and general counsel for Finney County. I have become a resident of Finney County. And I think that shows that my present also makes me a good candidate. I have been the solo municipal judge for Garden City and the first woman judge of Garden City. And then just in the future, I hope that my future part of my future would be to be the judge, one of the judges of Finney County. I believe, and if my research is wrong, you can let me know. I would also be the first woman of Finney County. I would be the first person who had an education from Duke and Georgetown in that position, and the first openly disabled judge. And with that, I'll say with the PPF, that would make me an outstanding candidate for this position. I also have a great passion for the law, and I've loved being a judge, and I would like to continue on the state level.
All right, thank you. Start the questioning.
Well, I'm happy to ask a couple questions because I just don't know you at all. My name's Rob Gale, and I haven't been able to go to the municipal court, but I understand that recently changed.
Yes.
What anything we need to know?
Well, I can't say everything that it involved, but I had a bifurcated role, and I worked as both the general counsel for the county, for Finney County, and as a judge for the municipal court. And I ran into some significant conflicts of interest. And because of that, I resigned my position. I don't think I can go into all of what the conflicts are, since some of them are confidential. But due to that, I think that I would like to think that I'm a very ethical person. And even though it was a very great job opportunity and I enjoyed my role, particularly my role as judge, I will not compromise my ethics.
Okay. Looking at all your past, which since I don't know you at all, I spent some time studying. It looked like you have an extensive journey, but you didn't stay at any stop very long. Am I missing something?
I'm not sure I would say that that's true. I think that I certainly have had I've had some contract jobs, which were, short-term in nature. And I also, for instance, at Georgetown Law, we were encouraged to, as much as possible, to work in a wide variety of positions, whether that was different internships during the summer. And I also worked while I was in law school. So that also gave me more of an extensive background. But I have worked in a lot of different places. That is true. I have run my own firm, and that may have been the longest place that I have been. I worked 5 years at Medicare. I have constantly, I think, moved up in the legal arena. So I think that the fact that I have a wide variety, a wide varied background is actually a plus for the judge role.
The time when you were running your office, you weren't licensed as an attorney, right? Am I reading this correct?
Right, and what I had stated was, and this was part of my disability, was that I was able to do some legal things, but not things in a full attorney capacity. I was able to practice in front of administrative tribunals. I was able to do things like negotiate and settle. But once, if things were to go to, and they usually didn't, because I was able to resolve them, to go to a court arena, then I would hand that to a partner attorney. That is correct. And I never signed legal documents as an attorney. I think one of the struggles for me, and that may be one of part of the question, that the first question that I was asked was, I have, despite having a good background and despite going to Duke and Georgetown, struggled with a chronic illness and not knowing what it was, and not having the right treatment for it. My illness is primary immune deficiency, and how I am treated is I get gamma globulin infusions, which are, quite expensive. They're more intensive than blood transfusions. I get them once a month. And I've had this all of my life, and it became more severe after law school. And, of course, working in the legal field, which is quite intense, with a chronic illness is a challenge. And not having the right diagnosis and not having the treatment for it made it very difficult. And, there came a time where I felt like I was ill, but not having the right treatment, but I still wanted to do as much as I could and keep abreast of legal issues. And so that's what I did. Rather than, sit back and go on disability, still was as active as possible, although I did let my licenses become inactive during that time. I was not formally diagnosed with this until 2018, and was able to get treatment, and then I became active again in 2013 in Missouri, and reactive in Kansas almost a year ago.
Judge, one of the things that those of us who
Just take time
practice,
for it to go by.
I'm sorry?
what I thought somebody else started to ask something.
Yeah, that's okay.
That we ran into in municipal court there was a lapse when you first took over, when you were waiting for your license to become active in Kansas. But there were also a lot of times when we would show up to court and there was no judge, and it seemed like people didn't know what was going on there. Can you address the amount of absenteeism when you were presiding in municipal court?
Well, I did get COVID while I was in Garden City. So there was a time period where I was out, absent. Yes. And I'm not aware of a time where there wasn't just a judge. So, you know, you may have been aware of that on your end, but I unfortunately was one of the unfortunate people who got COVID in late October and November. So there was some pro temps that filled in during that time. And there was a circumstance where my prosecutor also got COVID, and there was some lateness on the part of that where we had to slow court down, and we had the same issue with the bailiff, where one time we had to wait an hour for the bailiff fill-in to come. So we have had some interruptions on the municipal court side, mainly I think due to illness. We had COVID go around. We had to shut the court down again in October. We had a clerk that had COVID. I had 3 close calls with COVID where I was not sick, and then I'm not sure where I picked it up when I finally was diagnosed at the end of October. But I will say, and I think Ms. Douglas, you can appreciate that our dockets are and even if there was a later start time, occasionally, like you said, we had some hiccups. We were still able to, run everyone through and get everything done in a very expeditious amount of time. I mean, we had dockets sometimes as large as over 100 people, and still were able to complete that sometimes before lunch. So I think that would be a string too that I could bring to the state judge. I know that the dockets aren't quite as large, and certainly thinking on my feet and being able to handle a large amount of defendants was something, a skill that I picked up as a judge in municipal court.
Speaking of municipal court, my understanding is that there was a lot of turnover in the municipal court clerk's office during your time there. Can you speak to that at all?
During my time there, well, there's been substantial turnover in general during the clerk's office, but we did have a situation where there was turnover. Some of the clerks did not follow COVID protocol. I think that's one of the reasons that one of them got sick and then exposed the rest of us, and that had to be brought to the attention of management. Several of them were written up and put on performance plans. I think that led to some unhappiness and perhaps even accelerated some of the turnover. You have to follow the rules, and you have to keep people safe. And we have to keep people safe both in the court, and people that are running the court, and people that are coming into court. And of course, the municipal court in Garden City was unfortunate in the fact that it didn't have the capability to do Zoom other than inmates. So we had to be as careful as possible. And there were some clerks that did not want to follow the rules and be careful.
I'm looking looking at your resume. You indicate that as municipal judge, you oversaw over 100 staff members. Can you speak to that and tell me in what manner you were overseeing 100 staff members?
I think that is
Sorry, you just broke up.
I said I believe that to be a typo, and I apologize for that. It'd be more like tens. And so that would be something that I would correct on my resume. I apologize.
So with respect to the 10 people that you were overseeing, what was your role in overseeing them? What specifically were you doing?
Well, I mean, as the judge, and I think I had a shared role and oversight with the city administrator, I would oversee and work with all of the clerks there.
On here, it says that you remain contracted with the county. Are you still employed by the county currently?
Yes, I still do contracting work with the county. That is correct.
what do you consider home other than Garden City? I understand you moved, but where'd you grow up? Tell me something that your resume doesn't.
Well, I'm originally from Kansas City, and that's where I came from to work in Garden City. I grew up in Kansas City, and as you probably can see from my resume, spent most of my time practicing in Kansas City. So I actually have dual residence now, both in Kansas City, Missouri, and Garden City, Kansas.
Okay. So you grew up on the Missouri side?
Well, actually, I grew up in Johnson County.
Okay.
So I'm a Kansas girl. I'll say that, and went to school in Shawnee Mission East. Obviously, went back east to school. When I returned to Kansas City, I did live more on the Missouri side. About a mile or two from the border. I have a house on the Missouri side.
Thank you. I appreciate that.
What kind of contract work are you doing for Finney County currently?
Well, I'm continuing with a lot of the work that I had as general counsel. My role that I took when I was hired was general counsel for Finney and municipal court, and it was well, at least the way that they divide it is 50-50. They're no longer partnering in that capacity. And I believe that the municipal court person that they're looking for is just a solo part-time municipal court. But as general counsel, I handled all of the civil matters for the county, including all of the COVID work. And that's what I did.
What kind of contract work are you currently doing for Finney County?
I'm continuing a lot of that work, sir.
What is that work again?
A lot of the civil matters, all of the civil matters, actually, that Finney County has, and that could include employment, contract work, tax work, any matters that are on the civil side that aren't criminal, that would go to the county attorney work.
Without violating any confidences, can you just tell us what it is that you have pending?
I have some pending employment matters, and I have still some outstanding health matters, COVID, with the county. Those are the two main areas. I don't think I can get any more specific than that.
Are you still attending county commission meetings for the county?
I have attended county commission. I'm not there regularly. Actually, right now, I'm in Kansas City, but I attend them when needed. Certainly, I do. I'm not sure if well, actually, I can see you all at the top. If there is preparation work for the people that need to go, and if I need to advise the commission, then I will go there also. So I'm there I'm there sometimes, I guess I should say, Ms. Douglas. I'm not there every Monday, no.
When you say you're on a contract basis with the county, is there an actual written contract between you and the county for these services?
No, there is not at this time.
Very interesting.
So as a district judge, this is my pet question. As a district judge, you would be reviewing search warrants. Do you have any experience or exposure with those?
See ya.
In reviewing search warrants themselves,
Right.
I have no direct experience as a judge, no.
Okay. As a judge, as a district judge, that process is the last step between law enforcement and the ability to intrude into private citizens' homes.
Mm-hmm.
How do you view that responsibility?
Well, I think that's a significant responsibility, and maybe I should back up and say that I have experience on the private side of dealing with search and seizures and working in the criminal aspect. Actually, I mean, this was quite things that I worked on was a petition for cert to the United States Supreme Court as a law student about a search and seizure issue, about the intrusion of law enforcement into a person's home, and that violated the fruit of the poisonous tree. And I think that is something that needs to be looked at very carefully. It's not just a motion or let's say a search warrant or excuse me, arrest warrant that you can sign really fast and look at pretty quickly. Essence kind of democracy is how far do you let law enforcement in a person's private domicile. So those are matters that are of extreme importance and extreme significance, and something that would not be taken lightly if I were the judge.
Thank you.
There was some confusion when you submitted your application and delivered it, indicating that you were the current municipal judge, and the word on the street or common knowledge, everyone believed that your position had been terminated at that time. Can you speak to the timing of that without getting into the reasons for your termination?
Yes, I resigned my role. I'm echoing as municipal judge, but when I first filled out my application, I was still the municipal judge, and that and then that changed towards the end, and I believe I modified my. You can correct me if I'm wrong, but I believe I modified my application to show that I no longer was. I'm sorry if I created any confusion. I certainly didn't mean to.
Judge, you indicated that you thought that being an openly disabled judge was something that would be beneficial for the bench, and that being the first female judge was something that would be beneficial for the bench. Can you explain why you think those two things would bring things to the bench that maybe other candidates wouldn't?
Well, I think that anytime you have a diversity of people, that's a positive thing. Certainly with women, I mean, the more women that we have in high profile places, such as we have the first female vice president now, I think that is a positive thing. It shows young girls that it's possible for women to break barriers. I think being the first female municipal judge for Garden City was a good thing. I know that it varies, of course, county by county. There are some places that have multiple female judges, and then there are others that haven't hired a female judge yet. I think having a female judge in Finney County is positive. As far as being disabled, I know people have different views on that. And I think a lot of people maybe who have struggled with a chronic illness, or who at least have an invisible disability. Obviously, my disability is invisible. It's not something like I'm in a wheelchair or I'm missing a limb, or I'm visibly blind. It's not something that you can see. If that were something that you could see, that would obviously be a disability that was visible and an impairment that was open. But having an invisible disability and being open about it, I think, is a positive thing. I've been asked to speak at primary immune events about being an attorney and being and in my education and going as far as I've had, just to show that it is possible to go far. And I think being as open about it as possible is a good thing, and that people don't have to just settle for a life of disability or not being able to work in high profile jobs. And I think that that's a positive thing too. And I think it shows that the county is open towards diversity in all areas. I think it's all very positive.
So you see it more being a role model rather than this brings some additional insight into my position as a judge?
I think, I mean, that's a really good question, Ms. Douglas. I think it's both, honestly. I think it's both a role model, and I think there is additional insight, both as a woman and, someone with a disability, understanding what it's like firsthand to have one. Say, if an employment case were to come. Now, that doesn't mean that I would be biased, towards a case where, let's say, there's a disability discrimination, but it certainly would lend some form of understanding as to what that entails.
Okay,
So
thank you.
yes, I think it's both. Thank you.
All right.
Have you tried a jury trial before as an attorney or a judge?
No, I have not.
And what about a
And you-
divorce case? Have you represented a divorce client before?
No, I have not had a lot of practice in family law. I will say that. No, I have not. Let me add to that though. For instance, at Georgetown, and hopefully you can see this on my resume, I was in the sex discrimination clinic, and it's somewhat of a misnomer because we weren't per se representing women or people that were victims of sex discrimination on the job. It had to do with domestic violence, and it had to do with family law. So we did go. So I guess I should amend my answer and say yes, we did go to court. It was more in the interest of domestic violence, often obtaining restraining orders, that type of thing. But I worked all year in that clinic, and that was mostly judge trials, but that did involve family law, and that did involve domestic violence, and that did involve protecting victims of domestic violence, but that was not divorce per se.
Judge,
That's okay.
did I just talk over?
No, I think we were done. You're fine.
Judge, one of the things that stands out about your resume is the amount of time, and you both in education and in your legal career, you focused on women's issues and domestic violence. You brought up the domestic violence work that you did. So much of the domestic dynamic is prevalent in both domestic and criminal law. And so often we're dealing with he said, she said cases.
Right.
You feel like your education and experience creates any kind of bias where it would be difficult for you to set that aside and accept the idea that just because one person says something happened doesn't mean that it did.
Yeah, I understand what you're saying. And I think even on the municipal level, we had some he said, she said. So I have some experience of that as a judge, as well as, an advocate as well. And of course, in the area of domestic violence, it's ever evolving. I mean, we have more and more male victims. And while I do have a fair amount of experience, just like, for instance, being a disabled person doesn't automatically mean, I would fine for, let's say, someone who brought an employment disability discrimination action, or being a woman, I would automatically, side a woman, just like I wouldn't expect, for instance, an African-American judge to automatically side with the party who was African-American. I mean, I would like to think of myself as a fair person, and that I would come to every case, with a clean slate. And what that would mean, particularly when there are some things that come down to he said, she said, is judging really the credibility of the person. And I don't think that I would necessarily give more credibility to a person just because they were a woman or just because they were disabled. But I think that is a very big component to being a judge, is understanding the credibility of the witnesses, as well as the overall facts that back up their testimony and so forth.
Thank you.
Any other questions?
Can you give us a rough idea of how many trials you presided over in municipal court?
Well, as you know, in municipal court, it's more defendant heavy as far as first appearances and then case management. And of course, those days, particularly the Wednesdays and Thursdays, were the heaviest days. The Monday afternoons were the trial dockets. They didn't always, even though we might have some trials go to court. I would say that maybe I presided over, and this is just a rough estimate, I didn't keep count, maybe 24 trials. And, they could be anything from a small traffic case to, a criminal misdemeanor or several criminal misdemeanors. They certainly would not be as extensive of what I would see if I were the judge of Finney County, but I did have some trials. And, the challenging thing about the trials for me was I was expected to render a decision right then. I would hear the evidence, I would hear the witnesses. There may or may not be a police officer involved who would testify, and the trials would conclude. They would be relatively quick, but then I would be expected to render a decision right at the very end.
Did you deal with any?
I'm sorry, you faded out, Ms. Douglas. Did
you deal with any suppression motions while you were presiding as municipal judge?
I'm sorry, I still didn't catch it. It faded out.
Did you deal with any suppression issues?
Suppression of evidence. I did see some motions, a lot of motions on DUI cases that dealt with suppression, but those cases all resolved. So I didn't actually have to rule in court, but I did see a lot of those suppression issues come to my desk.
This John Linder, didn't you have a motion to suppress hearing with me on a case? Do you not recall that?
Actually, I think, Mr. Linder, you're right. I did. So I'm gonna have to amend my answer again. I did have one issue. I had several cases with you, and I remember, you being in court on several different issues. And I think that you were pleased with me some of the time and not pleased with me some of the other times. Sorry, I couldn't rule always in your favor. But I do remember having you in court, and I think I did have a suppression issue with you. Thank you for the reminder. There were a lot of cases, and I believe that I did have one with you.
All right. And while I've got the floor, you've submitted a letter of recommendation from Dan Likens and listed him as a person that the commission may contact. And Dan is certainly a well-known attorney in Topeka. You list him as a colleague of Governor Kelly. What is your association with Dan, and can you speak to the purpose of listing him as a colleague of Governor Kelly?
Well, just that since Governor Kelly is doing the selecting, I know that Dan Likens has had a number of high profile cases in Finney County, as a personal injury lawyer. So I think I listed that. I thought that was important, to note, since she will be doing the ultimate selecting of the judge. And I will also add to that, in addition to Dan Likens, in my capacity as general counsel for Finney County, I worked with a number of Governor Kelly's staff members and dealing with particularly health issues and some water issues and some other issues for Finney County. And I think that is significant for someone who's going to be considered for judgeship for Finney County.
Other questions?
What do you think makes that significant for a judgeship in Finney County? I mean, what aspect of that?
Well, I think, that could help. My understanding is that you pick 3 to 5 people to go on to the next level to meet with Governor Kelly. That might help be the nominee. I mean, certainly there's no guarantee, but that would be maybe one helpful association that Governor Kelly could relate to. I also think that, quite honestly, being a woman might be helpful. I know that government to appoint more women to the bench. I think that is also helpful. Again, not a guarantee, but helpful. So that is one reason I think I listed him as having. Dan Likens has told me that he has a number, for instance, of affiliations. Governor Kelly is a Democrat. With Democrats, that he regularly meets with Governor Kelly for lunch and so forth, and that he's also a relation of Joe Biden. And so I think I just listed that. I just thought that was interesting as well.
Anything further?
I don't. I do. I appreciate getting to know her. Thank you for applying.
Okay, thank you for your time. Thank you for allowing me to apply and to answer. Have I answered all of the questions that you have?
Seems like it.
Okay. Well, I want to thank you all for your time, and I want to thank you all for your consideration. And I think too, I guess I do get a chance for closing. I probably should address, because I feel like it's kind of still out there, and in the air, and perhaps, maybe even a negative stamp on my application. There was a mention of word on the street, and I know that, unlike Kansas City, Garden City is the smallest place that I've ever lived, and I certainly have enjoyed that. But there's good and bad that come to living in a small town, and that is that people know each other, I think, on a closer level and closer connection than perhaps even people do in Kansas City, and that it's quite easy to hear word on the street and things about other people that may or may not be true. And I know that when I started, I would hear this person is like this person is like that, and I tried to be as fair as possible. And from what I discerned, the fact that I left the municipal courtship, that the word on the street was perhaps not favorable. And again, I just would like to emphasize, and I wish I could get into everything. I think I can give one example, but I can't really give any others because I think it would give away confidentiality, is that the bifurcation, and I'll step back even a second. I remember when I interviewed, Miss Douglas, for instance, was on the interview panel. Miss Douglas, here you are again on my interview panel. Again, you're on a number of interview panels. I think that's very impressive and good for you. And I remember you warning me that there might be some conflict of interest. And I remember that in the back of my head. And your warning in some ways turned out to be true. And again, those two jobs, as we see now, are no longer combined. But for instance, one of the issues that I ran into was, the fact that the county and the city were splitting everything 50-50. I had a hard time, for instance, when I was getting my CLEs, if I had a CLE, for instance, that pertained to my training as a judge or a judgeship, that would always be covered. And then of course the bill would be sent over to the county. If there was a CLE that had to do with my role as general counsel, and there were a lot of CLEs I wanted to take because that was the first time that I was general counsel to a county, that would not be covered. And then I would have to go to the county separately and ask the county to pay 100% of that. And the terms of the contract between the two, and I don't think I can speak any more specifically, is that everything was going to be covered 50-50. And that's not how it worked out. And there were problems that ensued. And there were problems that eventually involved me personally, and I had to resign. And I don't know what exactly the word on the street is, but I would like to say that my ability as a judge was never criticized. And I believe I did a good job.
All right, well, hearing no more questions and having the closing statement, Ms. Camp will appreciate your application and your time today. And you can go ahead and jump off the Zoom meeting. And we have about 3 minutes until the next interview. Do you want to take a quick break, or do you want to dive into the next one?
Okay, thank you. Can you just let me know when you'll be making a decision? Do you have a time frame in mind?
Probably later this afternoon.
Wow, that's very quick. Okay, thank you.
I'm more than
Let's take
3 minutes.
That's fine. Remember, we're still on YouTube while we're in our break, so you should mute your mics and your video if you.
Justice, I've been looking around for the bear claws. Zach said that you were gonna have them delivered.
Well, Rob's already been asking for where the bear claws are, the donuts.
We got to get Justice Biles set up with DoorDash.
DoorDash.
That way he can DoorDash us some donuts next time.
I'll see y'all in a few minutes.
Shelby, do you see all the options down there now?
Yeah, I do, Kelly.
Okay. You should be able to control it from this point. So if you see under more, that's how you would stop the stream. So I am going to jump off and
Kelly, where
Kelly,
is more?
I'm still on.
The bottom.
I'm still on, Kelly.
Bottom right.
Okay.
You'll see more. If you click on that, don't stop the stream. But
I got it.
Okay. There you go. I'm jumping off. So let me know if you need anything.
Thank you.
Bye.
As soon as we get all together, Brian Sherwood is our next applicant. Ann, are you on? Can you hear us? Ann?
Oh, yes, I can hear you.
Great. I just wanted to make sure you were there. I can see everybody else.
Yeah, I'm here.
Great. Shelby, do we have Brian in the waiting room?
Yes, we do.
Great. Everybody ready to bring him in?
Yes, Your Honor.
Great.
We'll bring him in.
Well, Mr. Sherwood, the commission is all gathered, and I'm Dan Biles. I'm Justice on the Kansas Supreme Court. I'm a non-voting member of the commission, and I basically just organize things, and I've already failed at my job of bringing donuts to the certain members who are demanding them. But the way we'll proceed is to let you do a little opening statement, describe yourself, why you think you're interested in this job and why you think you might be good at it. And then we'll open it up for questions. And then if you'd like, at the end, we'll give you an opportunity to wrap up.
Thank you, Justice Biles. I appreciate it.
Go ahead.
Thank you. Hi, greetings to all of the nominating commission members. And I wanted to first take the opportunity to thank you for the opportunity to speak before you, before the panel in regards to this judge position. I'm humbled to have to be considered, and I will start with just introducing myself. My name is Brian Sherwood. I'm currently working as an assistant Finney County prosecutor here in Finney County, Kansas. I've been practicing law since 1990. I started my career back here in Finney County in December of 1990. I started under the county attorney at the time was Rickland Pierce. I eventually, John Wheeler Jr. was the county attorney. I worked with him the longest, and I am currently working with Susan Richmeyer, the current county attorney. And each one of those times I've had an opportunity to work with these individuals, and I've had an opportunity to I believe that I've had a positive relationship with each one of these individuals. During this time, my career has been primarily a prosecutor. But I've had a lot, over 30 years of litigation experience. Basically, as a prosecutor, you would take a case from the beginning, charge a case, take it to a preliminary hearing or whatever hearing that may be required. You may be required to go to a jury trial. I have done over 60 jury trials. I have been extensively in the courtroom pretty much for the last 30 years. And during that time, I have gained a lot of valuable experience before the court and with many different judges since 1990. During this time, I've had the opportunities to work with some fine judges, and I've been able to observe and watch what they have done. They each brought their own characteristics and traits, and it's been an honor to work before each one of them. During that course of the time, I've done just about anything you can think about as a prosecutor. I've done from misdemeanor and traffic offenses. I've started out as doing juvenile offender cases and child needed care cases. I also have done all types of felony cases from the very top, from the first degree murder all the way down to a traffic ticket. I've had numerous jury trials, murder, homicide jury trials. I've also had some specialization, at least in some part. A lot of the times when I was doing prosecution work, if there's a case involving a DUI or fatality, I was pretty much assigned to that because I had some experience in doing DUIs and handling those cases. During my career as a prosecutor, I've done quite a bit. I've also done a lot of appeal work. I've done close to over 100 appellate briefs. I've appeared before the Kansas Supreme Court and the Kansas Court of Appeals numerous times. That is a continued practice that we have here in this office. And when we take a case to trial, to a jury trial, that it usually involves a lot of appellate work. It also involves post-conviction hearings, whether it be mainly in the form of ineffective assistance to counsel or habeas corpus action. I've handled numerous actions in regards to that. Some of part of the duties I've done here is as a prosecutor. I've done some inquisitions. I've also had the opportunity to do civil forfeiture cases. I have handled civil cases. My primary practice has been prosecution, but I have had some experience in some civil cases. As I mentioned, part of my job description is also, for being here 30 years, I've had the opportunity to train staff. I've had the opportunity to train law enforcement. The law is a constant changing, it constantly changes, and it's important that as a prosecutor, you train your staff, you train your law enforcement, and also the lawyers that have come before here. I've been a primary source, I believe, that they can come to and discuss and get their practice off the feet, and to help them in situations that I've been through. So I've had 30 years of that, and there's been there's been a few prosecutors in this office. I've had a good relationship with each one of them. I've had the opportunity to help them as much as I can. So I've also done some special prosecuting in some other counties. As a judge here in the 25th Judicial District, I have extended my help to other counties. There have been some young prosecutors that have started, and they've called on me and I've helped them start their practice, and I've helped them advise them as much as I can. And I've been always available for anyone here in the 25th Judicial District. I certainly think that I have a good working relationship with the bar. I have, in my opinion, I've been approachable, and I know that a lot of times people will call and they would like an answer, and I try to give an answer to them as quickly as possible. As I stated, I've done major felony cases here in Fayette County for quite some time, and I've done extensive litigation. And as I stated, my primary practice has been in prosecution. and I've enjoyed it. But at this point, I'm in this part in my career, I think that I would be helpful to this community in being a judge. I've wanted to be a judge for quite some time, and that's a personal decision and a personal goal of mine. I believe that the experience that I have would benefit this community. I think you can't take away the experience in the courtroom. I think that's one of the best components to a judge is how much litigation experience they've had in the courtroom. You're always finding out finding out something new as you practice. And I think the best that you could have is the person that has litigation or litigation experience in their past. I certainly, my personal desire is to continue to help this community and the citizens of Southwest Kansas and the counties of 25th Judicial District. I would like to bring some of those characteristics that I've seen out of the judges I've seen. I've watched them exhibit excellent judicial temperament, and I would like to see the good qualities of a judge and use those good qualities of a judge to be impartial and fair and not biased. Qualities of a good judge include a good judicial temperament. You have to be courtesy. You have to be impartial. You have to have tact. You have to have compassion and firmness when appropriate. You have to understand how those decisions will affect the human beings, the people that are before you. And you have to have a little bit of humility, and you have to have common sense. And I certainly think during my practice, that has been something that I've tried to do as a prosecutor. I've tried to be fair. I've had the opportunity to work for law enforcement agencies and give them a fair understanding of the law. And then when it was time, at times when they felt, or I had to tell them or advise them that they had done something wrong or that they needed to correct something, I believe I've been able to do that. And I know as a judge, you have to take that, you have to have the courage and integrity to show no bias. And I certainly, as a commitment to being a judge in this judicial district, I would commit obviously to that I would show no bias towards my former office or in law enforcement that I've had to work closely with. I certainly, in those particular occasions, believe that under the law, the judge has to be fair, has to be unbiased, and has to be able to communicate and able to be courtesy, and has to be able to clearly understand, explain their decisions. As I mentioned, the experience is important. The information and the knowledge that I've gained through this office has been valuable. And my practice is, I found that working in the courtroom is one thing, but I found also appellate practice is a interesting level of knowledge that comes even more with this profession. I certainly abide by all ethics and believe that it is important to follow the ethics and what we were required to do. And I would certainly do so, and I will continue to do so and have done for 30 years. I certainly believe that I am a good candidate for this position. I believe that experience is a good quality. And there are times, and I understand my practice has been primarily as a prosecutor in the criminal law, but in regards to the areas that I may not have practiced as much, I still believe that I have the ability to look at the law, gain that knowledge, understand it, and be willing to get to the point where I understand and do what is necessary to understand the parts of the law that I have not has as much practice in. I certainly think that based on my history before, in this county and in this office, I believe that I've certainly shown that I can do that. I've tackled many tough issues and many different tough cases that have dealt with many complex different things. I could go on and on about what major cases I've done, but dealing with all types of witnesses, whether it be hostile or whether they might be a reluctant witness. I had a particular case that was particularly troublesome in terms of witnesses not wanting to speak. I had to practice with doing a lot of different things in that. I had to do a deposition. So I've had experience even in doing depositions in certain criminal cases. So it has come, those are examples that I've had to come across and had to deal with other issues. And as a prosecutor, I've had to deal with technical evidentiary questions. Some like, for example, when I was in the 1990s, DNA was a up and coming part of the law, especially in criminal law. And as it evolved, I had to deal with that in a couple of different cases early on. So, and there have been some changes to the law and changes in how evidence is handled and evaluated by the court. And I believe that is valuable experience. And that is certainly one thing that a goal is to bring back to this community experience. And I believe I'm the best candidate or one of the best candidates to be considered. Quoting Socrates, I'm certainly committed to do what Socrates quoted as saying is, hear courteously, answer wisely, consider soberly, and decide impartially. All of these are good quality traits and good characteristics of a judge. I certainly believe I've demonstrated that during the course of the profession. I'm willing to help. If I was accepted as a judge, I would be willing to help my fellow colleagues. I would be willing to help my fellow the lawyers before me. There have been times when lawyers have come before the court that needed assistance, and it's not a win at all cost for me. It is about making sure that that defendant, at least in some of the cases I've had, those cases that if an attorney needs some assistance, I try to help them as much as they can. I try to help them as much as I can. It is one of those things I think that I have been able to exhibit in this community, and I certainly want this bar to succeed. I want the 25th Judicial District to succeed, and I would like to continue my practice as a judge, and I believe that I am a good candidate for you to consider here today.
Brian, that was exhaustive. Unfortunately, Zoom cut you off 10 minutes ago when your time was up. You're recovering from knee surgery right now. Do you think that this job would allow you time to return to your part-time career as an Olympic sprinter?
Well, yeah, well, I think my Olympic sprinting days are over, but I think that, yeah, I'm doing well. I had surgery on the 23rd day of February. I'm doing good. I've been able to move around. I'm hopeful to transfer to a cane here shortly, and I'm doing rehab as required weekly. So I think that's coming. I'm hopeful to be back in 3 or 4 weeks, hopefully. Sooner the better. I'm certainly, I don't think that's going to interfere with anything. And it's something that I needed to do long ago, and I did it, and I'm glad I did it.
You've got a lot of great experience. I remember when your hair was a different color. The thing that jumps out, I think everyone on the commission is the civil side. What would you do to develop that part of your, I don't want to say lack of experience, but the civil side, the civil depth that you would need as a district judge? Have you thought about how you would develop that?
Well, I would do everything to take any continuing legal education or take extra classes or educational courses, law courses. I would do everything that I would need to do to come up to speed. I believe that my drive that I've exhibited in the practice I do now, I believe that I will be able to do that. I'm certainly willing and able to do the research and coming up to speed in regards to the civil side. I would be committed to spending the extra time. I certainly would reach out to people that have experience in this area, and I would ask that, and I would try to get some valuable advice, and I would continue to practice in this area and focus on making that part stronger as a judge.
Thank you.
Brian, one of the things that the lay people probably aren't going to be aware of is how much appellate work you do, how many briefs you write, and how much time you spend arguing in front of the Court of Appeals, and I presume the Supreme Court. Can you address how that would be a benefit to you as a district judge?
Well, I've done numerous briefs, and briefs can be sometimes as short as a couple pages, but as long as 50 pages. But it does take time to research. You have to analyze the issue. You have to identify the issue. You have to respond. It does take some time. It is a practice that I've had to I've had to do outside my hours here at the county attorney's office at times, because sometimes it takes a lot more time to prepare those items, even when you're practicing here, here in Finney County. So those you write briefs, and I've written over 100 briefs and 100 different types of motions that may be appellate motions. I've had to deal with that. So there's a lot of research and writing and crafting your arguments to the best way that you can make your arguments before the court, and that you stay on point and you cite the appropriate cases that are on point or that can support your argument. So having done all of that, I know that as a district judges, they do that and writing opinions and making decisions. And that is similar to what I am doing during the appellate practice. And I'm certainly, I believe, having done over 100 briefs, that is something that will continue, I would do as a judge and would be more willing to do. Sometimes I find it, as strange as it may be, it is somewhat exciting at times to write a brief that I feel that I'm getting into. So I certainly don't think that that's a problem. I think writing opinion is something that I could be able to do based on my experience in the appellate practice. And certainly I've made oral arguments before the Court of Appeals and the Supreme Court. That's part of the appellate practice, and that's part of trying to communicating your arguments and making the best argument for the court to understand. And I certainly believe that the appellate practice is a big part of, could be a big part of what a judge does here in the 25th Judicial District in terms of writing opinions for the cases that they have.
Brian, I appreciate you. I feel like I know you well enough that I don't need to ask much other than, is there anything about the judges we have seen in the 25th that you would try and emulate or that you would absolutely avoid?
Well, I've watched a lot of different judges, and I think one thing that I've come to appreciate is the judges I currently practice. They show a lot of patience, and they show a lot of. I've watched them, and I'm kind of. It's interesting because they have been able to show how courtesy a judge can be, how impartial they can be, and how tact they can be. And there's times when they have compassion and when they have to be fair and have to be firm. I've been at dockets where certain defendants like to go a little bit off. They get off centered a little bit. And I've seen the judges, they were able to bring it back and bring these people back to understand that their voice is going to be heard. They just need to understand the process. So I've enjoyed that. I've have practiced for some judges that have been in short at times, and that has not been, in my opinion, something that was that would help. That's not something I would want to do. I think watching the judges, I currently watching the judges I've seen now, I've come to appreciate the hard job that they have, and I certainly would emulate some of those characteristics that they've done here recently. It actually makes it more enjoyable to be in court. To have these judges perform the way they do, and I've learned a lot here just in the last 10 years. And I've been here 30 years, and I've seen different judges, and I've seen quite a bit different styles. But the last couple of judges I've seen here lately have been really what I'd like to do is be more compassionate in terms of having an access for these people to have their voice heard, having the parties and the attorneys be able to make their arguments, and for them to understand that there are two sides, and both sides need to be heard. So I've come to appreciate what a hard job they've done.
Brian,
go ahead, Lucy.
Sorry. As a prosecutor, you've dealt with some controversial and high-profile cases. There have been cases you've been involved in where, the community was somewhat up in arms, and you've sometimes had to make unpopular decisions. How do you think that would be a benefit to you as part of the judiciary?
Well, and that's part of the courage and integrity of a judge. You have to have the ability to make tough decisions, even though they may be unpopular, or they may not be something what people want. The point is, you have to apply the law as it is to the facts of that case, and you have to make a decision. You have to be unbiased. You have to be able to make it, and you're going to have to make tough decisions. And during my career as a prosecutor, I've had to make tough decisions. I've had to explain to either law enforcement, this is not something we can do. This is not something somewhere we can go. They may have been not happy about that, but I have applied the law, and I have given my best advice to those folks. And I think they've come to appreciate that. I think they appreciate somebody with experience. They understand that. And I think that's something that a judge has to go through. And I've certainly gone through that, and making tough decisions, either whether to charge a case or to decide to do something with a case. Previously, I look at the evidence. I have to weigh that evidence. I have to decide. Yeah, I have to make decisions based upon the facts that are before me and the law that it is. So I have, and that's part of it. The other part is, when you make tough decisions, you have to be able to communicate with those people and try to explain your decisions so that they understand. And I certainly have done that. And, we have victims at times that have gotten upset, and I've given them time to explain my decisions or decisions that we've made in the case. And certainly as a judge, that's another part that you would have to do. You would have to explain your decisions, and you would have to explain based on the facts and the law. And I certainly think I could do that. I've certainly done that. That is one of those things you have to do as a prosecutor, probably more times than not. But those are things that I certainly can do as a judge as well.
Brian, let me ask you a quick question that I don't think we've touched on, but we sort of have some trends going on right now. One of them is we're kind of down on cash and corporate surety bonds, or bonds have become much lower than we've been used to, as having done this for a long time.
Sure.
I want you to comment on that. And the second thing I'd like you to comment on that I think Finney County generally was opposed to, that you're maybe not, was plea bargain mediation. So speak to those 2 points, please.
You know, the law evolves and changes, and I think there's been a commission to decide on bonds, and they have studied the issue, and I give due deference to what they've looked at. Certainly, some of these low-level felonies, the bonds don't. I don't necessarily agree that they have to be that high. They can be lowered. Some of them have to be taken consideration with the type of crime that was committed, and I think the courts do that. I don't think they're. I know that the bonds have been lowered, but I still believe that the courts and the judges here are taking, they're looking at the case itself. They're looking at the law regarding bonds, and they're looking at the person's background, and they're making that decision. And I'm not opposed to the lowering of bonds. I think when it needs to be, the bonds need to be appropriate when it is a person crime or it's a domestic violence crime. That's obviously, I think the courts are taking that into consideration. That's certainly what we would have to do. In regards to mediation, I don't necessarily disagree with mediation. I think what's important as a prosecutor, you have to communicate that with the victim if you have a case involving a victim. And that's a big component. Sometimes the victims don't understand the mediation, but mediation is something that could be used. And I've seen it happen. Actually, we've had it. I think I participated in a mediation case a couple times, but recently it's been used more. And I think from my understanding is that it has benefited in resolving certain tough cases. And sometimes that's not a bad thing. There are going to be cases that need to be mediated. Not every case needs to go to mediation, and there'll be times that a prosecutor may have to decide that's not right. So I think mediation does in the criminal field help. It's been used in the civil side, I think, obviously quite extensively before in other areas of the law. And so I certainly think I don't see any problems and using mediation in criminal cases as well.
Okay, Brian, I have to do it. As a prosecutor, you review search warrants with law enforcement. That's how we do it here in Finney County, right?
Correct.
And have there ever been times that you've told law enforcement, I don't think you've got it here, please go back and work on this some more?
I've done it numerous times. I would sit there and say, you guys don't have this. This isn't, I'm not taking to the judge. I will tell you what I know. Having experience with the certain judges I've had here, I've been able to, I kind of understand. I understand how they might react. So yes, I have told the law enforcement, you need to go back and there needs to be more information to get probable cause. For 30 years, that's been something I've been doing. I from the very beginning till now, I will give them my opinion. If there's not something that I believe there's probable cause, I will tell them, and I don't have any problem. I think a lot of those law enforcement, they appreciate that I tell them that they don't have enough probable cause. I think they appreciate it because I think they understand where I'm coming from and where my experience is from. So I've never had a bad experience when I've told law enforcement. They may have been disappointed, but they understand and they would go back to work and try to do what they needed to do. So yes, I have done that numerous times before.
Are you more inclined to do that if you know you have a judge that's going to really scrutinize that search warrant versus somebody who's likely to kind of skim it and sign off on it?
I would, if I thought a certain judge would not spend the time on a search warrant, I would spend more time on it, and I would make sure that we would have those things. I would do that for any case, but I made it a point if the judge didn't see something or he missed something, I would ask him to reread it, go back over it, and I would make sure he understood what he needed to understand in that search warrant, because, you know, sometimes he'll miss something, and sometimes it would be crucial to his decision whether he would grant it or not grant it. So I want to make sure the judge, I want to make sure every time I go before a judge, he knows what the facts are for that search warrant, and I've done so. I don't take shortcuts on that, and I would never do that. I would make sure the judge understands what the full facts are.
Why do you not take shortcuts on that?
It doesn't do me any good as a prosecutor down the road. It's certainly, it would violate somebody's constitutional rights. I'm careful about that. I don't want to go down a road and violating anybody's rights. It's important that those rights are protected. I'm an officer of the court, and I'm required to do the best. I'm not, you know, a prosecutor goes to court and is responsible for prosecuting cases and obtaining convictions, but it's not to win at all costs. It is to be, we're an officer of the court. We have a responsibility in making sure that justice is done, not just for us as a prosecutor or the state, but also for the defendant. And, you know, my experience dealing with this, it is having to deal with issues with defendants. We want to make sure that they have their rights protected. Those are the rights under the Constitution, and it was important to me as a prosecutor. It's important to me. It would be important to me as a judge, and the opportunity would. I would continue to be the same way I've done now. I would do as a judge.
Thank you.
You're welcome.
Any other questions? Well, seeing nothing else, we've got 7 minutes before our next interview. That may not be long enough, Brian, for you to close.
Well, okay, touche.
But I'll give you that chance.
I'll make it brief. Once again, I appreciate everything that all of you coming before you. This Zoom practice is a little bit different. We're all going through different phases in it, and I appreciate it. But I want to appreciate the time that you've taken here to listen to what I have to say. The only thing I would like to add and is, you know, my commitment to this community and the 25th Judicial District is something that I've been a public servant since 1990. I want to continue to help the citizens of the Southwest Kansas 25th Judicial District. I believe I'm a good candidate for the position for judge, and I believe that I can continue to do the things that I've done in the past, and certainly as a judge to be fair, impartial, explain my decisions, to listen to the individuals who come to the courtroom, to have access. I certainly would, as a judge, would like to improve on the judiciary or help out. There are things that, as a judge, that to make things better. For example, I know the 25th Judicial District is considering drug courts. I think that's a positive step in the right direction. As a prosecutor, I've seen so many people that their lives have been ruined by drugs, and they need to address it. I've given, you know, not everybody needs to go to prison. The people that are bad and need to go to prison need to go to prison, and I certainly have good common sense in that regards. I think there should be some access, better access to the courts, and I think that's something everybody's trying to improve. I certainly want to improve the judiciary, especially out here in Finney County. We have to deal with interpreters a lot. That's something I would hope that it's been good. But we can always get better. And I think that I as somebody, as being a judge, it's not just one thing to sit up on the bench and make a decision. It's another thing to also give to your community back in terms of trying to help access to the court, also being available to speak on occasions to people that would be helpful in the community. Of a public speaking engagement requires, or is available, I would be willing to do that. Those are opportunities that I think as a judge, we can continue to help this community, not just Finney County, but the whole 25th Judicial District. And I'm excited. If I become a judge, I would be excited to do this. I would be ready to go. And I certainly would, I would have an open door policy that anyone that would like to come and talk to me. I certainly think that those are things that are important. I will certainly take the good character traits that the judges I've seen here, and I will emulate them and use them to the best. Once again, thank you for considering me today.
Well, thanks for your time and applying and your interest in the service to your community. So with that, we'll conclude this interview. We've got 3 minutes before the next one. Does everybody want to take a quick break, and then we'll just reconvene at 11:30 with Mr. Frock, or do you want to just go forward? It's up to you all.
Yeah, we should break. Yeah.
All right, let's take a break and we'll come back in 3 or 4 minutes.
Thank you.
Yes, true, very true.
Okay.
Sure, sure. And why not? Please, go ahead. Plunge.
This ought to be good. What if there were any splashing?
That's all I need. Okay. Let me run over there and just pour just a little bit out.
Good.
Well, it looks like we're all together here. Ann, can you hear us?
Yes, I can.
Great. Do we have Magistrate Frock in the waiting room, Shelby?
Yes, we do.
Great. Well, if there's nothing else, let's go ahead and bring him in.
Bringing him in.
There we go. Magistrate Frock, can you hear us?
Yes, I can.
I was just going over your material. You know, I'm Dan Biles. I'm on the Supreme Court, and I'm the non-voting member of the commission. I think when you interviewed, Brad Ambrosia substituted for me at the commission.
Back in Syracuse in 15 or 16.
Yeah, I got tied up. Anyway, the process that we're using here is we'll give you a few minutes to do a little opening to introduce yourself to the commission members, to talk about why you're interested in the district court job and why you think you might be good at it. So we'll let you do that, and then we'll start in with questions.
All right. Well, thank you, Justice Biles.
Go ahead.
Oh, I don't see everyone on the screen, so I'll assume everyone's there. Would you like me to begin with my opening statement, Justice Biles?
Yeah, everyone is here. Ann Wiles does not have a camera, and that's why she's not on. Everybody else is participating.
I see. Well, I think I should probably get the elephant out of the room and answer the question why I want to be a district judge. And it's a very simple answer. It's because I'll be good at it. The only way to be good at something is that you like it. And as my 5 years as magistrate here in Scott County, I like being a judge. I understand that to be a good judge, you have to check your ego at the door, simply because you have to understand that while you have your own story, that every individual that comes before you, they too have their own story. They too have their own set of circumstances. They too have their own different situations that are much different than yours. And as a magistrate, it's really hard to affect the change that.
Judge, they're fixing to put you in. You're not in yet.
Oh.
I'll let you know when you're in. Okay.
I've been told by my clerks I'm not in.
Oh, we've got you.
You're in.
You're good.
Is what I said, should I repeat it or?
No, you were on.
Okay, thank you, Justice. No, but I understand, as I mentioned, that when you become a district judge, you have to check your ego at the door, just as I do here. But also, some of the changes that I would like to see affected can't be affected by a magistrate. They have to be affected by a district judge. And as a result, I want to be a district judge to affect those changes. And as I said, I'll be a good district judge because I've learned how to be a judge while serving as a magistrate here in Scott County.
All right, questions?
Judge Frock, this is Bill Heidman. I'm over here at Zachary Schultz's office. You just indicated that as a district judge, or one of the reasons you'd like to be a district judge is that to affect some changes that you can't otherwise make as a magistrate. Can you go into more detail about what changes you're seeking?
Well, Mr. Heidemann, I think our district needs a drug court. It's very possible that our district needs a veterans court or a mental health court. As I mentioned in my resume, the county attorney and I, county attorney being Ms. Farrow, we have individuals that come before us with a variety of drug problems or have committed crimes as a result of drug use. And we have been able to convince them to attend facilities that I'm familiar with, primarily in Oklahoma, the Howe Foundation, which is a 6-month program at no cost to the individual to go for men only, or First Step, which is in Moore, Oklahoma, just south of Oklahoma City, where women go for 6 months. At each of those facilities, we've had a roughly 60% success rate with people coming back and saying, well, I've changed, or 2, I'm going to move from Scott City because I'm not going to fall back in the same hole I just crawled out of. Those facilities, and there are more, there's one in Colorado, there's different ones in Oklahoma, and they're all 6 months programs. They allow us, they have a 12-step meeting each night. They have personal counseling each day. And these individuals, for example, at First Step, the ladies either work at Dunkin' Donuts, or they work at the dry cleaners, or they work at a variety of other places. They're responsible for their own behavior. They're responsible for holding down a job in order to pay their room and board. Now would be the extreme of drug court when you've reached the end of the line with these folks. But if a person can be treated or helped locally, whether it be by AA or NA, then that's acceptable. But what drug court would require would be that you would come to court, you would plead guilty because you have to accept responsibility for what you've done. So it would have to be a guilty plea. And then sentencing would be held in abeyance until you completed the program. Now, the program may be from 12 to 18 months long. It may require random drug testing on the spur of the moment. They may assign you a color, for example, red. And if you get a phone call at 7 in the morning, say it's a red day, you've got to go to the probation office or the law enforcement center and take your drug test. And there are various levels of, I should say, disciplinary actions you can take. Minor ones, during the drug court meeting, which would be held every month, you would possibly be slightly humiliated, or you could be subject to 3 and 5 days in jail. Or if you completely and utterly failed the program, then because your sentencing has been held in abeyance, you could be sentenced to the original plea offer that was announced at the time of the plea. This would, and just because you might fall into a prison box, it would not stop you from being a participant in drug court, because if you completed the program, then the prosecutor and the judge and the defense attorney could then say, we're going to reduce your charges to misdemeanor, grant you a departure, whatever it may be. So it's not only a way of treating individuals, but is a way of keeping people who maybe deserve to go to prison according to the grid, but keeping them out of prison and letting them try to be productive members of the community.
Thank you.
You're welcome.
Judge John Lindner, have you proposed these programs to be implemented?
I no, not to the not to the district judges, nor to the appellate courts or the administrators of the appellate courts. I have mentioned it to the district judges, but Ms. Farrow and I, as a county attorney, we simply took it upon ourselves to say, these people are not dangerous, except possibly to themselves. And if we give them the opportunity to go somewhere outside of Scott City for 6 months and attend the AA meetings and the personal counseling, that maybe we can turn their life around. And as I've mentioned, we're probably batting 600 when it comes to that. Some of our folks, Ms. Highschmidt moved to Pittsburgh, Kansas. Mr. Johnson's now a welder in Oklahoma. And the list goes on as to people that we have been able to help by sending them to these 6-month programs. But that's the only avenue that Ms. Farrow and I have because of no proper drug court facility here, in that we don't have counselors, we don't have a dedicated CSO. So as a result, that's what we've been doing. And as I said, it's been quite successful.
Is that something you think you could do as a district judge without the buy-in from your local county attorney? What if Rob Gale over in Syracuse said, we ain't doing that in Syracuse?
I think you could. I think you could. Whether it's done by mediation or the district judge has the final say insofar as if a person enters a plea of guilty, how long the sentencing will be held in abeyance, and what type of sentence will be imposed. So I think it could be implemented. It would take a cooperative effort amongst the defense bar, the prosecutors, CSO, community corrections, Compass. Yes, it would take concerted effort. And I'm not going to pretend that if I became district judge tomorrow, that it would be in place the next day. It's probably going to take 6 months to a year to implement it. But once it's implemented, then it should run somewhat like clockwork. And in most instances, or at least a majority of the instances, it will be successful, not only for the person that's a participant, but for the community in and of itself, and the people that this person may or may not associate with.
Would you allow Rob Gale as a participant?
Yes, I would allow Rob Gale as a participant if there were a client on the other side of Mr. Gale, and Mr. Gale wanted to place someone in drug court, then by all means that person could participate in drug court, and it would be district wide.
Well, that was a joke, but
I know, I understand. But
this is serious. You mentioned veteran or mental health court. Totally unfamiliar with that. Is that something where an individual maybe is just short of qualifying for a care and treatment? What is that? Obviously, you have some prior experience with that.
Well, the prior experience, I don't have any prior experience with Veterans Court, but I was fortunate enough to watch the Veterans Court seminar that was played late last year. And veterans have their own set of problems with PTSD, with homelessness, with other types of mental illness. And I'm not a veteran, so I'm not going to speak as a veteran. But that would probably be somewhere down the line after the establishment of a drug court. And it would not, just because you have a so-called drug court, it would not prevent a veterans court or a mental health court from kind of running alongside it, considering that many people that suffer from the use of illegal drugs also have a mental illness. And many are veterans as well. So they could run alongside each other, but not being a veteran, I don't really have their perspective as I do being a criminal defense lawyer for all those years and dealing with folks that have problems with controlled dangerous substances.
Ed, this is Gene Gady. You've been the magistrate there in Scott City and seems to be kind of a comfortable fit and things seem to be going well up there. What do you think the benefit to the entire judicial district would be if you move up and leave Scott City as magistrate?
Well, the benefit to the district, I think, would be that after being in private practice for 20 some odd years, as well as being a public defender here for 1 year and a magistrate for 5, there's probably not a case that I have not seen at some point in time during my career. I've done hundreds of divorces, which required me to have the Advil concession when I was in private practice. But I've done hundreds of divorces. I've done hundreds of jury trials. While here in Scott County, I've been exposed to sink cases, having to determine, the best interests of the children, and the other factors that go into play in a sink case. So there really hasn't been anything that I haven't been exposed to during my career. So if I were to be made district judge, then I would be prepared to go to court tomorrow, whether it be a jury trial or a divorce trial or any other type of legal matter that would be presented to me.
Your jury trial experience, is it all criminal or have you done some civil jury trials as well?
Most of my there weren't jury trials. Most of my civil trials were divorces. I did 2 or 3 civil jury trials, but most of my civil cases seem to evaporate or settle out of court before they made it to trial.
Have there ever been instances when the state and the defendant have reached a plea bargain during your time as a magistrate and you haven't followed the agreement of the parties?
Maybe once or twice, but I can't think of any cases in particular. And I'm sure that if I've refused a plea agreement, they're fewer than 2 or 3.
You have any recollection about what the basis for that would have been?
I think certainly one, the victim had not been consulted. One, I believe I had some familiarity with the defendant, and some people, as we know, do well on probation, others do not. Others, when you place them on probation, you simply set them up for failure. And I think there was a couple of instances, maybe when I was doing misdemeanors in Finney County, that rather than set someone up to fail, it would have been better that they did 5 or 7 or 10 days in jail and not have the obligation of having to go to a CSO or take UAs. But those are the only times I can remember.
And what about on recommendations for bond? For instance, is the parties agree bond should be X, OR bond $5,000 cash, whatever. Has there been times when you said, no, I'm not following that agreement?
Yes, there have been times that I've done that, because the severity of the crime lended itself to a higher bond than possibly what the parties may have agreed to. And the threat to the community that the defendant may have posed was greater than what the parties may have agreed to in the form of their bond. The two circumstances that I look for are, one, evidence that the person may flee, or two, whether that person is a continuing threat to the community. And I will say that in the spate of child pornography and child molestation cases that I have been set bond here in Scott County, I have disagreed with the bond recommendations by the parties because I considered those individuals threats to the community. I set a $500,000 bond on a gentleman that Judge Worst reduced to $250,000 bond with an ankle bracelet. For example, that's the last one that I've had altered by a district judge. But I know those are the two considerations. And as an independent in a lawsuit, I have to think not only what's best for the parties, but I have to think of what's best for the community as well. And if I consider someone to be a threat for the community, it may be that I do not agree with the bond recommendation.
Ed, let me weigh in on that issue just a little bit. I haven't been fortunate enough to be up in Scott, but I do know that there has been a trend of late that pre-incarceration bond is probably disfavored, and bonds therefore have gone lower. And you are somewhat of an, at least reputed to be an outlier on that, liable to have a higher bond or a cash bond or some of those things. And maybe that's dated. Maybe that was in your first year or so, but speak to that, because that's the one beef that I have heard down here about Judge Brock is he's unreasonable on those issues. And I have no experience in it. So give me some thoughts.
Well, Mr. Gale, all I can really tell you is what I've said before. The two considerations are flight, whether this person is a flight risk, obviously, if he's not been a member of the community for an appreciable amount of time, or if he lives out of state, or if he lives on the eastern side of the state, his risk of flight is probably greater, so his bond should be higher. But the other factor is this person a continuing threat to the community. And if I consider that person a continuing threat to the community or society, then his bond is going to be higher. I am not going to pretend that a person who has been charged with possession of child pornography or child molestation or those type of crimes, I am not going to tell you that, no, those people aren't a threat to the community at all. In every instance, they may not be, but those type of charges lend themselves to the fact that you may very well be a threat to the community. So those are the only two factors, Mr. Gale, that I'd look at. I don't know what folks consider high bonds and what low bonds. My misdemeanor bonds are typically $2,500 or $250 cash. And normally when they put up cash, I tell them, well, I hope you pay your court costs with it when your case is disposed of. Typical possession of CDS, somewhere between 5 to 10, depending on what your criminal history is. But no, I don't think that I'm outlandish with my bonds. Otherwise, the jail would be full, and it's certainly far from full, considering that we've already filed 40 cases up here this year.
Do you think that there's a difference when you're setting bond when the parties in front of you disagree about the bond versus when the parties jointly recommend a certain bond?
Mr. Schultz, would you repeat that question, please?
Or do you think that there's a difference as the judge when the parties are jointly recommending a bond amount versus when the parties disagree over the bond? Do you think that your analysis should be different as the judge?
Yes, because I'm to be independent. The judges have to be independent of the parties. I can't take the defense side. I can't take the prosecutor's side. I have to make up my own mind as to what the bond should be. Because the parties agree on something, don't take offense by this, but just because the parties agree on something in a criminal case doesn't make it right. In a civil case, if the parties can agree whatever they want to agree to, and I'll sign off on it because I'm going to presume that the lawyers and the clients have been fully informed and this is what they want to do. But in a criminal case, where not only the parties are involved, but the citizenry of the district or the citizenry of the state of Kansas is involved, then I become an independent contractor, so to speak, and I will make up my own mind as to what I feel the proper bond amount should be. Many cases, the victim has not been consulted. Obviously, if the victim were to come in and say, let him out, or set a $5 bond because I have $5 in my wallet, I will 99.9% of the time do that. But I not only have to look out, as I said, after the rights of the parties, but I have to look out for Scott County and the citizens of Scott County as well in any criminal case that I do. I'm not sure if that answered your question, Mr. Schultz, but.
Yes, thank you.
Any other questions? Well, if not, Magistrate Frock will give you a couple minutes to wrap up if you want.
Well, Justice Biles, as I mentioned, if I were made or selected to be a district judge, I would try to implement a drug court within a year or so. Obviously, the subject of bonds has come up. Obviously, I can't make any promises as to bonds because each situation, each case, each defendant is different than the next one that's presented before me. I will be, whatever the Supreme Court of the United States or the Supreme Court of Kansas should dictate to me as to what proper considerations are for the setting of bond. But at present, as I mentioned, it is risk of flight and threat to the community. And those will be the two primary considerations when I do set bond. Having experienced done many divorces, I know what to look for in a divorce. Having been divorced myself, I know why people get divorced. And I know that the primary consideration in a divorce is the best interest of the children and not always the best interest of the adults. All I can tell you is that with the experiences I've had in running the gamut of cases that I've either had to try before a jury or try before a judge, that if selected, well, we'll hit the ground running. And thank you, Justice Piles.
All right. Well, thank you very much for your time. We are scheduled to resume at 1:15. Our applicant will be Timothy Woods. If anybody on the commission got anything to say, otherwise just mute and turn off your video and is that right, Shelby, for the lunch break as well?
Yes.
Okay, then just we'll see you back at 1:15 if there's nothing else.
Thanks, Ed.
Thank you.
Okay.
Bună că-i bun, am iubit. Bună că-i bun, am iubit.
Hello, Bookbin.
Yes. I need to find out. I'm with LFA, and I need to find out if you have a certain book.
Okay. What's the name of the book that you're looking for?
It is called Black Rednecks and White Rebrows by Sowell Thomas.
Yes, I do. I just saw it this morning. The title jumped out at me.
Okay, so, and
Well, I turned light on. It's not quite time, almost.
I said, you got a moral obligation to support that kid, but you don't have a legal obligation at this time.
Right.
Yeah.
Yeah, so when you have the, yeah, live right here. Yeah. It's like that. That's what was required. Get up. Quit. I'm sorry. I would pay back every guy. That's a class.
Hey, retired Gene Gady, how you doing?
Very good, Rob. How are you, sir?
You know, you look to be thriving.
Well, I thank you. Well, I thank you.
Well, it's 1:15 and I see we've got everybody but John. Ann, are you on?
I'm here.
Good. So our next applicant is Timothy Woods. Is he in the room?
He is. Are you guys ready for him?
Where's John? Do we know? Okay, we'll just go ahead. I mean,
John told us this was the earliest he had been late in a long time.
right. And I was going to say something like that. I was actually about to praise this format for hurting some of you in a more timely manner, but can't do that now. John's ruined it for all of us. Okay, let's go ahead and bring Mr. Woods in. And
Okay, I'm going to bring Mr. Woods in.
Mr. Woods, can you hear us okay?
I can hear you. Can you hear me?
Yeah. We've got everybody on the commission present with the exception of John Linder, and we expect him to show up shortly. So I think we'll go ahead so that we can stay on time. And our format here is going to be the same as we've done in the past, which is to let you have a few minutes to give an opening statement if you like, tell us why you want this job, why you think you might be good at it. Then we'll open it up for questions and then give you a chance to wrap up at the end.
Okay, thank you.
So go ahead.
All right. Good afternoon, the Honorable Justice Biles, Mr. Secretary, members of the Nominating Commission. I'm honored to appear before you today as a nominee for District Judge. I would first like to take the opportunity to thank the countless family members, friends, mentors, and colleagues who have done so much over the years to make this day possible. I am extremely grateful for their love and support. I want to make a special note of thanks to my wife, Michelle, our daughter, Nova, and our 2 foster kids. They have done so much to support my legal career, and for that, I am eternally grateful. This commission nominates a district judge to serve all the citizens and residents of the 25th Judicial District, from Garden City to Tribune, Scott City to Syracuse, and all points in between. That judge will take an oath to support the constitutions of the United States and the state of Kansas and faithfully discharge the duties of their office. Since becoming the Finney County District Magistrate Judge last year, I took it upon myself to better serve the citizens of Finney County by expanding the previous magistrate caseload and take on half of the child in need of care cases, all the misdemeanor criminal and traffic cases, all the protection order cases, and uncontested pro se divorces. Despite the significant increase in caseload, I have always been prepared for court. I always treat everyone in front of me as a valued individual, and I always strive to make sure that everyone leaving my court feels listened to and respected. My time on the bench could not have happened without the amazing opportunities given to me during my 11 years in practice as an attorney, first with Kansas Legal Services, and later with Young Williams Child Support Services. I learned a great deal from my supervisors and managers, Marilyn Harp and Brandy Ridgway, and most of those lessons have become the foundation for how I run my courtroom, where I am dedicated to following the law and being committed to fairness, making sure that the parties and attorneys before me are treated with respect. Yet, despite all the experience and knowledge previously gained, I refuse to be complacent and satisfied only with what I already know. In my spare time, I like to visit the OJA Education website to review past trainings and training documents, as well as sign up for judicial trainings as they are offered, learning whatever I can to become a better judge and fill in the gaps of what I don't know. I am confident in my ability to handle all cases that come before me, whether it's criminal, domestic, civil, probate, or administrative. Beyond learning to be a better judge, I have also working to be a better leader and manager. I believe this is especially important for this judicial district as, in the next couple of years, we are probably going to have 2 new judges, and soon after that, a 3rd. So when that happens, I want to be in a position so that whatever needs to be done, I am ready for whatever role I am called to fill, whether that's to serve as chief judge or to assist the chief judge with the administration of the district. While I did not have a great deal of experience being a judge before the pandemic came, I have worked hard to adopt the technology that is now so vital to making sure that the courts can remain open while also protecting the safety and health of the people who appear before us. When this pandemic is over, I look forward to continue using this technology to increase access to justice for everyone, reducing the burdens on those who have a difficult time being able to travel long distances to attend court, as well as helping those in the outlying counties to have hearings sooner rather than a once a month when the district court is in their courthouse. If I am nominated and then appointed by Governor Kelly, it will be another step in a career dedicated to serving the public and ensuring that everyone receives an equal opportunity to have their disputes settled before the law in a just and fair manner. Further, if I am appointed, I promise that I will live up to the oath of my office and serve the citizens and residents of the 25th Judicial District to the absolute best of my ability. Thank you.
All right, thank you. We'll open it up for questions.
Judge Woods, this is Bill Heidman. I'm sitting over here in Zach Schultz's office with Gene Gady and John Lindner. Reading through the resume and knowing you as I do, it doesn't appear that you have much jury trial experience or kind of an extended, deeper civil trial experience. If that is the case, would you please tell us how you intend to get up to speed in those areas, or what you've already done to get up to speed in those areas?
That is a fair question. I will say that since I've taken the bench, I have been on the OJA training website. There's a couple previous trainings to deal with conducting jury trials in a pandemic, as well as some old trainings regarding how to prepare new judges for jury trials. There's an especially helpful lesson that was provided by Judge Gehring out there in Wichita. I've reviewed it. I've talked it over with Judge Frederick, and he sees that lesson from Judge Gehring as a very basic, great start to prepare a new judge on how to handle a jury trial. Covers everything from how to seat the jury, how to voir dire the jury, and how to manage the jury throughout the trial to minimize the risk of a potential mistrial. In addition to that, I have had a couple of cases since taking the bench where I was expecting to have a jury trial, should it have been able to happen due to a pandemic. And in order to prepare for those jury trials, I read the relevant statutes, looked up case law, talked to the other judges so that I would hopefully be ready for when that time came.
Thank you.
You're handling the misdemeanor docket right now, is that correct?
Yes, that's correct.
Okay. And prior to becoming a magistrate, you didn't have any criminal experience, did you?
I had one case when I was with Kansas Legal Services that I had to work to prepare for a bench trial in front of Judge Pierce when he was the magistrate. I felt I was very well prepared. I thought I had a great defense ready, and then my client didn't show up. So,
oh, that's life.
And
Can you talk a little bit about that? Like, I mean, how you've handled, handling that criminal docket that you do now without having done it in practice, and how you've made that transition.
Again, like a lot of the foundation for how I handle that docket was learned from talking to other judges prior to taking the bench and since taking the bench. I'm also a big fan of an old saying from one of my professors at Washburn, Dean Kincannon. He liked to say that all you got to do is read the statute and don't think great thoughts. So I always start with the statute. If it's an especially complicated case, I always reread the statute prior to addressing any complicated issues in a case, because while anybody, especially a judge, can think they know the law, it's always best to make certain and to reread it ahead of time. I'm also not opposed to asking attorneys before me for advice on how other judges have handled it, so I get a sense of how they like to see things run in particular.
Tim, I haven't had the opportunity to be before you directly. I've heard good things about how you've handled your docket, and I know you've taken on quite a workload. One of the things that I think is going on in the district is we are, to some degree, evolving a little bit philosophy-wise, and one of those changes is in pre-trial incarceration and the whole bonding thing. If you've given much thought to it, where do you come down on the spectrum of bonding?
I've been on duty several times. In fact, if you ask my wife, she will say I've been the duty judge too many times. So I've had plenty of opportunity to set bonds. Generally talk to judges about it. I think Judge Frederick has said it however I feel comfortable. But in talking to Judge Wurst, who is on I can't remember the name of his committee, but I guess it's the pretrial detention task force, something like that. He talks about favoring recognizance bonds, and that is generally my position, that certainly on lower level crimes and people who don't have a lot of history of not showing up to court, I generally favor releasing people on their own recognizance with the admonition that they are expected to show up to court, and that if they don't, they could potentially face being locked up prior to their trial. I think that it's important for people to be released because there's a burden upon the counties having to lock people up for extended times prior to a trial, especially when there's a presumption of innocence. And it also doesn't benefit the community as a whole, because you're taking someone who may be supporting their family or working a job, and then their employer is out, a potentially a valued employee, and their family is out, someone who can support them.
Thank you, Tim.
Word is, Judge, that you're a little heavy on your bonds on the criminal side, particularly on violations of protective orders and that sort of thing, without a great deal of regard for the particular alleged facts. You think that's a fair criticism?
I think in the few cases, I think that could be a fair criticism, but in rethinking the issues, again, because usually violations of a protection order are lower level crimes, there should be a favor towards releasing someone on their own recognizance. But I think in certain situations, depending on the facts of the case, if it appears that the person is engaging in behaviors that put the alleged victim at risk of great harm, there has to be some kind of bond. But yeah, certainly not a very high bond.
Tim, where do you come down? Do you, if prosecutor and defense attorney have reached a recommendation either as to a sentence or as to a bond reduction or something, do you feel like you give great deference, or that's just a factor among many?
I generally give great deference to any recommendations for sentences or bond reductions agreed to by the parties. I trust the prosecutor to represent the interests of the citizens of their county. And I'm sure that the prosecutor and the defense attorney know a lot more about the case than I do, since oftentimes the only thing in the court file relate to anything that's been filed by the respective attorneys or the charging affidavit filed by the police. So I guess to sum up, I generally give great deference to any agreement reached to by the prosecutor and the defendant.
Well, I've heard good things about you, Tim, so I appreciate your comments.
Tim, it seems you've done a good job setting up the juvenile docket, both sync and juvenile offender, and also the criminal and traffic. What would be the benefit to the district and the entire judicial district to take you out of that role and move you to the district judge?
I believe that I can take the skills that I have learned and developed and already have as it relates to how I handle those dockets, such as patience and the ability to let people feel heard, and to expand it to take on more complicated cases and cases that have potentially much higher stakes than the cases that I have before me. I'm not saying that sync cases don't have high stakes, because those cases could potentially result in termination of parental rights, and that's perhaps for a lot of people in this district, that's the highest stakes of all. So I believe I'm prepared to handle more complicated and higher stakes cases. On top of that, back when I was in law school, I always had a particular interest in family law. And while I can handle uncontested pro se divorces, I think that I would be a terrific resource and asset to everyone in the district should I be able to handle more complicated divorce cases due to my previous knowledge and skills.
Tim, one more question for me. Do you have any opinion as to whether or not it's beneficial to the district to move towards drug courts or specialty courts, or can we handle it with our existing systems?
I think drug courts and specialty courts are a good idea, but it's going to take a lot of buy-in from the community, and it's going to take a lot of recognition that it's going to take some upfront money, and it's a matter of convincing the powers that be that that's the way to go. I generally favor finding a way to prevent someone having to go to jail or facing charges on their criminal history, if that's available, if we can just give them the chance. So I guess what I'm trying to say is that I would like to see drug courts or veterans treatment courts or other similar specialty courts. I recognize it's going to take a lot of work, and that's work I'm willing to put in if there's buy-in from the community.
Judge, I want to follow up on Gene Gady's question. Obviously, if you become a district judge, you leave a big hole with your magistrate duties. And from people I've talked to, you've done an excellent job handling, very important child in need of care matters, termination matters. You've taken on a lot of other responsibilities as a magistrate. And so do you feel as though by becoming a district judge, you're leaving a spot that perhaps you're more valuable for?
Sorry, just give me one moment. I need to think about how to answer that. I will say that throughout my legal career, I guess you could say that I've left a trail of people who were disappointed when I moved on to bigger and better things. I mean, I know my boss with Child Support Services, Brandy Ridgway, was especially saddened to see me move on, but I felt it was something that was good for my legal career as well as that of my family. I know that there's going to be a big hole when I leave because I took the magistrate position, which handled relatively a great deal fewer number of cases than the person who previously handled the job for me. But I still think that if I move on to be a district judge, the ability to handle more complicated and more higher stakes cases is something that I can take the same energy that I've applied to being a magistrate and apply it to being a district magistrate judge.
Thank you.
Sorry to interrupt, but I think one more thing is that if I am a district magistrate judge, I can mentor whoever takes over for me and teach them what I've done to be able to handle such a large docket. And I think I want to take this opportunity to praise the person from the prosecutor's office I most often work with, Mr. Jacob Gare, in that he and I have worked together very well, and I'm sure that he'll work together with whoever would take over for me if I am elevated to the district judge position. So I'm confident that at least in terms of the misdemeanor, criminal, and traffic docket, whoever takes over, it'll be in good hands.
Judge, one of the things that I think everybody has been impressed by is your willingness to uphold constitutional principles, even when the facts suggest that perhaps eventually, let me see how to word this. You put constitutional principles ahead of facts and protect rights well. Can you speak to that belief system and how you think it would benefit you in a district court position? I know magistrates don't have as many opportunities to deal with those issues as district court judges, and this seems to be a strength and a passion of yours. So I thought I would give you an opportunity to address that.
Say that, I mean, since my days of being in law school, constitutional law has definitely been a passion for me, especially as it relates to protecting a person's fundamental rights. and their ability to be treated equally under the law. And also the Bill of Rights. I've had one case come up where it was a question of whether or not a person was properly detained in order to determine whether or not she was driving on a suspended license. But I believe I know the particular class particular course. Sorry, give me one moment. The particular case you're talking about. I've always had a strong belief that the Constitution is the basis for all law in this country, whether it's the Constitution of the United States or the Constitution of the state of Kansas. And I remember learning somewhere that, people complain that people get off from their crimes or get off or basically get what they want in a particular case on a technicality, but I never view it as a technicality. I view it as the system's protections for someone's constitutional rights. So as in all cases, if the Constitution trumps the facts of the case, then that's just the way it is. And that's a particular passion for me.
Well, that makes a nice segue into the next thing that I always try to ask about. I see judges as the last line of defense between law enforcement and intrusion into people's homes. And so I always want to ask about search warrants. Have you reviewed search warrants? I mean, have you been search warrants to sign while you were duty judge?
Yes, and I have reviewed a few. There were a couple that were for out-of-state matters, and I always had to tell the officer that I would love to help them, but as a magistrate judge, my powers end at the border of the district. But as in all cases, when the warrant came before me, I always took the time to read it to make sure that it met the minimum requirement that there's probable cause to believe that a crime was committed and probable cause to believe that particular evidence of that crime is present wherever the officer is looking to search. Is kind of a segue. I'll kind of talk about my past before going to law school. I had wanted to be a police officer. I had attended a California Police Academy and I made it through 20 of 24 weeks of training before I failed out because I just don't have the heart to engage in combat with people, apparently. And I want to say that a lot of that training and a lot of the stuff that the training officers drilled into us was a respect for the Constitution. And I believe I've carried that forward to my time as a judge, and that I'm able to see things not just as a lawyer and a judge, but I'm also able to see things from how a police officer is supposed to handle things. And I will say that while I have yet to see a warrant that has a problem that I would not approve, I believe I have the courage to point that out to the officer that there's nothing there and they either need to go back to the drawing board because I am not going to approve that warrant.
What is your philosophy on the issuance of no-knock warrants?
That is a large issue, especially given what's gone on in the news. I believe that it would definitely depend on the facts of the case, whether or not a no-knock warrant is necessary. And on top of that, it would have to be a sufficiently serious case to justify it. Both for the risk to officer safety and for the risk to the owner of the property that is being searched. So I guess ultimately I would be very skeptical of issuing a no-knock warrant, and it would fall upon the officer and the prosecutor to convince me that there's a very good reason why there needs to be a no-knock warrant.
Thank you.
Any other questions? Well, seeing none, Magistrate Woods, would you like to wrap up with a closing statement?
Thank you, I would. Again, Justice Biles, Mr. Secretary, members of the nominating commission, I really thank you for the opportunity to allow me to come before you to make my case as to why I should potentially be the next district court judge to replace Judge Pierce. I believe I have the necessary temperament and patience to deal with everyone who comes before me. I am a strong believer in making people feel that they're being treated equally and fairly under the law, and that when it comes time for me to make a decision regarding the people in front of me, that they know exactly where I'm coming from. They know exactly the basis for my decision, and that hopefully they can see from their situation why it is I ruled that particular way. I look forward to taking my career to the next level, to serve all the citizens of the 25th Judicial District. And I look forward to being the best possible judge. And I promise that if I am selected, I will do the absolute best that I can to serve the citizens and residents of the 25th Judicial District. Thank you very much.
Thank you, Tim.
Thanks, Tim.
Thank you.
Thank you. We've got the next interview at 2 o'clock, so I would suggest we just pause for a moment and come back at 2 o'clock like we have been.
All right. Thank you, folks. Am I free to leave?
Yeah.
Thank you. Have a nice day.
Yeah, Lucy was having lunch that she's pulled up the YouTube version.
Justice Biles, I got at your direction, I got the donuts.
I was trying to figure out how to send an apple to you. I thought that might.
Well, I just wish we'd have had a little bigger budget, but nevertheless, we're gonna have a donut here.
No, okay.
Okay, I saw Ann's sound come on, so I'm assuming she's there, right?
Yes, I am.
Good. And everybody else is in place. So, Shelby, would you bring Miss Cott in, please?
I will. Here she comes.
The trade-off.
I saw that.
Miss Cott, good afternoon.
My sister.
Good afternoon, Miss Cott. I'm Dan Biles. I think you might remember me from the last round that we had on this. I'm a member of the Supreme Court. I'm a non-voting member of the commission, and I guess it's just my Zoom and YouTube account that we're using here. But anyway, we're going to use the same format for your interview that we did the last time. We'll let you make an opening statement and explain why you're interested in this job and why you think you might be any good at it, and then open it up for questions, and then give you a chance to wrap up at the end. So please go ahead.
Thank you. Good afternoon, everybody. Just what you want to be doing on a Friday afternoon. It's good to see you all again. It's been about a year and a half since I was last in front of you, so I won't try to bore you too much, but just to give you a little background, since it has been some time, I did grow up in South Dakota. I went to college there. I was a collegiate athlete. I played softball and I was the captain of my team. After that, my husband and I, we moved down to Kansas, specifically to Garden City. And we both joined the public defender's office, working together here with the idea that we would live here for a couple of years and then move to a real city after that, after we got some experience. However, we fell in love with the community and now are raising our family here. I have a 6-year-old and an 8-year-old, a kindergartner and a second grader. I'm in private practice right now as well. So we've built a nice life here and we really love it here. I've been here for 15 years now. For the first 9, I did work at the public defender's office. I got promoted twice while I was there. I was an assistant to begin with, and then I was promoted to deputy, I think a couple of years into my service over at the public defender's office, and then was eventually promoted to chief public defender there. With that 9 years, I got a lot of experience. I did a lot of criminal jury trials, including becoming death penalty certified. I handled a death penalty case in the Wichita area when they ran out of qualified people to take on a case because there were several co-defendants on those cases. So I've been to death penalty training and got to do that as a part of my time with the public defender's office. After that, I moved over to prosecution for 5 years with Ms. Susan Richmeyer, who's our current county attorney. And I was considered a trial attorney there, handling cases all the way from off-grid, Jessica's Law, sex cases, murder cases, and then I would also handle traffic court as well, so just simple traffic tickets. So I've seen a wealth of cases there. Just this last year, I made the wise decision right before COVID hit to go into private practice and give up my steady paycheck. So I've been in private practice for the last 13 months, and it's been great. I've been able to grow my experience and experience new things. For the last year, I've been handling a lot of child in need of care cases. And that has just been great because it's spilled over into other areas of the law that I hadn't touched on yet. So oftentimes in child in need of care cases, you will have to do parenting plans. So you start to get into the family law aspect of it. And the divorce cases, I haven't done divorce cases yet, but I've been dabbling in that area. It's also led to me learning about adoptions, guardianships, Care and treatment cases I was already familiar with as a prosecutor, but now I've gotten to do it on the defense side as well. So I think all of that experience would make me a good judge, a good district court judge. In all of that, I also learned how to do appellate writing, appellate briefs. I've had to do many appellate briefs. And so all of these things together, with my perspective of being on both sides as prosecutor, as defense attorney, and now in private practice, being a mother, bringing my life experience to the bench, I think that that would be a good balance. I also think that I have a good judicial temperament. I think I'm patient. I think being a mom helped me a lot with that, and learning that, and I can bring that to the bench. I think that we have a really good group of local bar members. I really like the sense of community, and I really like going into the outer counties as well. That was one of the best things, being at the public defender's office and what I'm doing now. I got to travel to Leota, to Tribune, to Syracuse, and to Scott City, and experience all of the 25th Judicial District, because at the public defender's office, we handled all of the counties, not just Finney County. So it wasn't all just about Garden City. So it was great to get out and be in front of the judges and everything like that. So I think that that's why I would be good at it, because of my experience and the fact that I'm a hard worker.
All right, fine. Any questions?
Christy, I'll start off. One of the things that we've been asking, or I've been asking and interested in, some of the changes that I see occurring. One of those is in the philosophy of pretrial detention. The second thing that I'm seeing is there is a little more acceptance of criminal plea bargain mediation. Would you give me your thoughts on those topics?
Sure. Obviously, I'm a big believer in the Constitution, and I believe you are presumed innocent. And I believe that when I was a prosecutor and a defense attorney on both sides. Obviously, there's very serious crimes that require high bonds, where there's public safety is at risk, crimes of violence against people, crimes against children who cannot protect themselves. In those instances, I do think a bond is required to protect the community. But in lower level crimes where you're going to be presumed probation, I often thought it was kind of ridiculous with the notion that if you got convicted of a crime, the judge would be required to release you from jail after you've been convicted. But when you were presumed innocent, that you could not be released on an OR bond, that actually being convicted was a way to get out of jail. So I don't disagree with the reforms, but I think that you can still protect the community as well. In the cases where it's needed. So that's my philosophy on bonds. I think you had a two-part question. Was there another?
Second one was mediated plea agreements.
I have no problem with that. I think sometimes it just takes getting all the parties together and to see it from another perspective. I think that it can save the community an awful lot of time and money in cases that should be settled. There are cases that just simply can't be settled, and for reasons, maybe it's very serious or you're just too far apart, but most things can be worked out. And oftentimes I see even just having a preliminary hearing, for example, when you have your defendant sitting right next to you, sometimes when they actually see the evidence presented in front of them, they get a new perspective on their case. And maybe they think, well, maybe there are things for me to think about. And I think in mediation, that's something similar, because you're getting a third party perspective that's not connected with either side. And they're pointing out the pros and cons of the cases to both sides, to prosecution and to defense. So I have no problem with utilizing those tools if they're available.
Thank you.
You're welcome.
Krista, you talked about that high bonds are required when you have persons that are victims or children or sex crimes or those types of things. What if you have an agreement or recommendation between the prosecutor and the defendant to grant a low bond or an OR bond in a serious case like that, while a plea is being reached or awaiting sentencing or something like that? Is that something that you would defer to, or what are your thoughts on those instances?
Absolutely. If you're on the bench, you only know so much about a case, maybe the affidavit and it. oftentimes cases are not how they are presented at the very beginning. There's facts that come up afterward as far as the discovery process that the judge would not be aware of. I trust that there's a reason for that recommendation and that it's just not a crazy recommendation. I also know how frustrating it is when you are in court and you have an agreement and then the agreement is not followed, how frustrating that can be. And obviously you all know it, especially all the attorneys know how frustrating that can be. It's very hard to gain trust with your client or your victim on the other side. It's hard to gain trust when you can't tell what's going to happen in court and without a degree of certainty. Of course, the judge always has the final discretion, and I would always warn my clients that, and I realize that. But no, I would definitely give great deference to that. And if for some reason I had a problem or didn't feel comfortable with it, I believe the way I would approach it is I would want to talk to both sides in my chambers for you to explain further why you were doing what you're doing, so we could have an off-record discussion about that. So I was fully educated on it. If I was feeling uncomfortable with something, I would always give you a heads up.
My other question is, my assumption is that you've never gone through a civil discovery extensive case. How would you as a district judge manage what can often be best described as a standoff or disputes on civil discovery process when we don't have that experience to draw upon?
Litigated it, sure, that's definitely a fair question, but I'm not afraid to talk to others and reach out to others. I have actual personal friends that are district court judges. I think there's a good working relationship here where I could draw from other resources other than just reading the statutes and the law, of course. And then also I am in the middle of litigation with my son, so I have been following that. We are suing for injury that happened to my son. So I've been following that case and going through that discovery process, and it's with a big firm out of the Kansas City area. So they have been throwing all of their top dogs at us. So I have been involved in that deposition and going through that case as well. So that's educated me as well.
Christy, as far as work-life balance, I've always admired, watching you from afar anyway, with your terrific relationship with your kids and family. You're very active with them. And as we know, as in private practice, we can kind of set our schedules. We can go to our kids' events and we can, knock off early or whatever the case might be, which those in public service, such as a district judge, may not have that same freedom. Have you considered how being a district judge may impact the freedoms that you have now as a private practitioner to enjoy some of your family and other outside activities?
Yes, big consideration I had before putting my name in, and I talked to my husband about that as well. And we made a deal that if I was fortunate enough to get this, that he would still be in private practice and that he is going to promise to be closer to home and help out with the kids as well. Public service isn't anything new to me. I know it takes hours away from my family, but I feel like the time that I spend away from my family is worth it because of the help I'm doing to the community or my client or the state, depending on what side I'm on, and it's valuable. And I wouldn't spend time away from my kids if I didn't think what I was doing was important and valuable.
Thank you.
Christy, in reviewing your application, I'm just curious, what did you do the 3 years between college and law school?
I was a business major. I wanted to own my own restaurant. I worked all throughout law school and I was a server and I really liked the atmosphere there. So I was a business major and then I went and I started managing a restaurant right out of college with my undergraduate degree. And then I realized that I didn't think it fully through, that I would have no life because restaurants are open on weekends and in the evening, that's when they're the most busy. So I decided to get a day job and I worked at Citibank and I worked in retention sales. So I worked in sales there called in to try to close your credit card. I tried to convince you otherwise. And if I was successful, I got a commission off of what you spent on your credit card in the next 6 months. I absolutely hated it, and that's what drove me to law school.
Okay.
Christy, one of the things that has struck me every time you've considered a change in your career, you've reached out and sought resources to familiarize yourself with whatever you thought you would encounter there. I recall times that you contacted us to ask for recommendations for books on domestic law and things that would assist you in transitioning into private practice. How do you think that thirst for knowledge and willingness to prepare yourself would be beneficial transitioning into a district judge position?
Thank you, Ms. Douglas. And that was something I was going to address in my opening statement. So I'm glad you brought that up. No, I just love learning. And so the great thing about this is, and that's why I love the transition from defense to prosecution now to private practices, so I can keep learning new things. There's so many things in the law that I don't know that I would like to know. And I just find it very exciting. And so reaching out like to your office, like you mentioned, and getting resources, I think I have the ability to learn those areas that I don't know yet. And I'm not afraid to ask for help if I need help. So
your husband frequently says that you're the smarter of the two in the relationship. Is that a fair characterization?
Actually, I think he's the smartest person I know.
He says that about you too.
That's why we're still married, I guess. We were high school sweethearts. I've known him since I was 17 years old. So we got something working.
Christy, I know that I've asked you about this before, and I'm going to ask you again just in case I forgot the answer, or just because it annoys everybody. One of the things that I always want to know about is the philosophy with regard to reviewing search warrants. I think that piece of paper is the last, or the judge reviewing that piece of paper is the last protection between law enforcement and the sanctity of an individual's home. And I know at the county attorney's office that you would have been part of reviewing applications for search warrants. As a judge, how would that experience being in that role assist you, and what is your personal philosophy on how you will approach and evaluate search warrants?
Thank you. Well, I take it very seriously. It's our constitutional rights, and we have to protect everyone, even if that means somebody did something bad and maybe doesn't get convicted of it. It's not worth giving up our constitutional rights. There were often times where law enforcement would come over, especially when they were learning, where it was a search warrant that wasn't time, they didn't need it right away. Maybe the car was already in evidence and impound, and they were learning how to write a search warrant. So they would bring it over, and they would send over new detectives that were just learning so we could review those. So that way we could help point out the deficiencies in it where they had time to fix it. So it could be a learning process. So I've seen deficient applications for search warrant, and ones that I said I would not bring to the judge without further investigation. I have caught stuff after the fact where maybe I wasn't the one to review the search warrant, or maybe suppression issues came up later, and actually dismissed cases if I thought violations of their rights happened, and try to correct the situation as soon as possible. But I think it's very, very serious. Search warrant is a serious thing. And if there's not probable cause, I don't have a problem being the unpopular one. I don't mind making unpopular decisions if that's what needs to happen to protect everybody's rights.
And what is your philosophy with regard to no-knock warrants?
I think for a no-knock warrant, you would have to not, of course, I'm for officer safety. I appreciate law enforcement. I think they do a good job. We need them in our community, but it can't just be a general vague, we need this no-knock for officer safety. They need to be able to articulate clearly to me the need for it, the immediate peril of either the destruction of evidence or law enforcement being injured, but be able to articulate exactly why, and not just a blanket for officer safety.
Christie, on the subject of search warrants. Apparently, there have been some seminars that prosecutors out here in Southwest Kansas, some of them have been to, and they have come back with the idea that if they're going to seek a blood draw, they should always get a search warrant. They are presenting an application for a search warrant to magistrate judges that say all of the standard stuff. This is why I suspect DUI, so on and so forth. But then they say the defendant is concealing evidence of the crime within his body. And then they go on to ask for the search warrant. When in truth and in fact, in many of these cases, the individual has consented to the blood draw under the implied consent advisory law. If you were presented with that conflict, which I see as a conflict, where you know they've consented, yet the prosecutor has instructed the law enforcement officer to bring you an application that says the individual is concealing evidence of the crime, how would you handle that?
So just before I answer that question, are you talking about where a person in custody verbally consents, or just because of the implied consent laws?
No, an actual consent. They've been given the oral and written implied consent advisories, and they have agreed to take the blood test. But on the instructions of the prosecutor, the officer then takes them to the or takes them through the search warrant process before he takes them to the hospital.
Well, if I understand what you're asking me correctly, it sounds like everything that's in the application for search warrant isn't true and accurate, and they have to swear that it is true and accurate. So if there's facts in there that said they already consented, that does not mesh with that they are concealing evidence because they offered for the blood draw, if I'm understanding you correctly. So that doesn't make sense to me.
Well, that's certainly my position, but it's going on. So I just haven't had anybody that wants to push it yet. So.
And that must have happened after you left the prosecutor's office, because I mean, I haven't had that in my personal experience in the 25th Judicial District.
Yeah. You would see that as a conflict in the affidavit and application for the search warrant, and you would reject the request for the search warrant.
If they correct the affidavit, I think they could still get the search warrant, but it doesn't sound like all that information is driving up with each other. So I think there's a way that it could be corrected where they could still get the search warrant, but that could not be true and accurate if you have conflicting pieces of information. And if I'm understanding your question correctly.
Well, if you ask that it be corrected and you got the information that they had consented to the blood draw, but the law enforcement wanted the search warrant instead, would that resolve the conflict, or would you still see a conflict there?
I think what I'm hearing is that they're trying to cover their bases. They're trying to make sure that the blood sample does not get rejected, and they're going a step above and beyond. I guess as long as the information is true and accurate and they're requesting a search warrant, if maybe there's a language barrier. I mean, I don't know the specifics of your case, but maybe it's a questionable consent. And I have been in that situation where maybe they are so intoxicated or there is a language barrier that it's unclear if they did consent. And in those cases, I always thought it was proper to get a search warrant for the blood draw where it's blurry. But in your instance, is it a clear-cut consent?
Yes. Yeah, after written and oral advisories, yes, I'll take it. And instead of going to the hospital, then they go through the search warrant process.
Sure, without researching it more, because I haven't heard of this issue until you just brought it up. I think as long as all of the information is correct in the application for search warrant, that shouldn't preclude you from granting a search warrant. And if they did clearly consent on your end, I don't see how it would harm your client because they already consented. The blood is going to be drawn one way or another. So I don't see how that would be fatal to the case, but with more research, I could be wrong.
Any other questions? Well, Christy, if you don't mind, you've got an opportunity here at the end to make some closing remarks if you like.
Thank you. Just briefly, I do have an update to my application. One of the questions that was asked of me was if I had any outstanding taxes due, and happy to report those have been paid. So if I make it through to the next level, it should be no problem to get my tax security clearance certificate. So I did want to update you on that we have taken care of that. COVID kind of hit us hard. Like I said, I made that smart decision to leave my steady paycheck right before the court shut down for 3 months. So it was kind of a difficult year. But so I wanted to update you with that. And I think that I said a lot in my opening statement, but I do want to let you know that I appreciate your time and the opportunity to see you all again. I hope that you give me the opportunity to go through to the next level. I would be proud to go back to public service and service all of the counties here in the 25th Judicial District. I'm hardworking. I like to learn. And like I said, I'm not afraid to use the resources around me when I don't know something. So thank you so much for your time, and I appreciate it.
Thank you.
Thank you, Chris.
Thank you. Nobody called me back.
You can jump off.
Thank you.
Christy. Well, we're a little bit ahead. I'd like to,
Hold on.
we've got a few minutes. Do you guys want to take a break and come back at 2:45? Start discussing the applicants, or do you want to just up to you?
I have no problem getting started as long as being off the agenda is not a problem. I'd kind of like to keep at it and get done.
No, I think we're fine to just keep talking.
That's it.
I'll just let anybody jump in. I don't, I don't want to inject myself too much into this process, but I think you kind of know what you have to do. And, there's a variety of ways we could go about doing it, but we have, after talking to Bill, we really don't have any other option other than to conduct ourselves like we would where we can be seen. So we're going to need oral motions and discussions like that. We don't really have the ability to do ballots virtually.
I think we have previously sent Christy and Brian up to the governor. I don't see anything has changed in their qualifications. If anything, they are more qualified than they were the last time we interviewed them and sent them up to the governor. I don't see any reason why they wouldn't be appropriate as two of the candidates to go up.
Lucy, this is Tom Walker. I agree. I have kind of made a list after sitting through all of this. I have 4 candidates on my list that I would be comfortable sending. I have, Chris Velez. I would feel comfortable with Chris. Brian, I feel very comfortable with him. Tim Woods, I would feel comfortable with, and also Christy Cott. Right off the hand, that would be my preliminary list. I would strike out Ms. Kent. I don't feel she's got all the qualifications we're looking for. And for one reason or another, don't have a good feeling with Ed Frock.
I'm curious because the questions were kind of dominated by law training folk. Besides Tom, I appreciate that, Tom, very much. Any of the other lay folks have some wisdom or questions, because generally you say something that I wasn't smart enough to think of.
I guess I agree with Lucy in the fact that from previous interviews and today, we've sent both Mr. Sherwood and Ms. Cott before. The aha, I guess I had was the idea that and I really wasn't expecting this, but the idea that maybe there's some desire, at least by one of our candidates, to try to implement some change. I don't know if that's even doable at the district level or not, but that was interesting to me, and I certainly think that I understand the need for sure. All of our communities more and more are fighting the issue of illegal drug use and filling lots of space up that maybe could be changed by different routes. However, I don't know. I guess if I had to pick three, I'd say Brian and Christy and Mr. Frock, but that's just me.
Christine, for me, the top is easy. I think it's Brian for me at the very top. I put him in first.
Christine, I can't hear you. We're not hearing.
Trouble hearing you.
Oh, okay. Ann and I are sharing the room, so we can't both have our audio on. So I guess you either get my audio or my face. So right now you'll get my audio, but this is Christine. And I said for the top, I think it's easy for me. It's Sherwood. From there, it gets a little blurry. And then I think the bottom's easy for me too, but the middle, I'm still a little blurry. So.
Okay, and this is Ann, and I very much say yes to Brian Sherwood and to Christy Cobb. And I'm thinking on the others. Maybe Timothy Woods.
You know, I've been impressed with, well, obviously Brian and Christy. I mean, I feel very comfortable with them. And just as Lucy said, we have sent them before. They are extremely experienced, familiar with the other judges, the local bar, so on. I don't have any issue at all with them. I said this one time before. I've always been a Tim Woods fan. I think he's exceptionally conscientious. I know for sure that he works very hard to be the best that he can be. I think any of the remaining candidates are a little green in some respects. But I think Tim Woods, he has taken on quite a big role as a magistrate to take on some of these extra dockets. We saw again, just like we did when he was chosen as a magistrate, he's methodical. You ask a question, he thinks about it, and then he answers, which has been something I've never been good at. And I think if he's presented with an issue, a complex civil litigation issue, a difficult a criminal issue, I believe that he would, just as he said, he's going to go to the statute, he's going to research it, and I think he's going to give a well-reasoned opinion. I think his temperament, I think he's shown that he is even-keeled. He's not difficult to approach and talk to. Those are the three that I'm most impressed
with. Secretary Bill, I would I would agree with your comments, and taking this one step further, we have three very well qualified, I think, candidates in Brian, Tim, and Christy. And if we look at either Ed Vrock or Chris Velez, we're going to be back here in a not too distant time to do this all over again, to replace or find a magistrate for Hamilton County or Scott County. I think those two magistrate judges are well placed where they're at. I think they fit well with the communities, and I would kind of support your comment that the other three candidates would serve well if any one of the three of them were selected.
This is
I don't disagree with any of that. Tim, go ahead. I didn't mean to step on it.
That's okay. I just was saying that when I originally went through all of them, my first three picks were Brian and Tim and Christy as well. So
I just want to say one thing, guys, that I think Chris Velez has greatly exceeded my expectations. His quote that he gave you, well, I generally find that stuff corny. That was extremely insightful because it's pretty much a reality. His temper has never been a problem, but then again, I've dealt with some really difficult judges elsewhere at times. But anyway, I give him high marks locally. I am tickled to death to keep him. But I did want to speak up on his behalf. And as far as Ed is concerned, I don't have much experience with Ed, but the couple of times I've dealt with him, he's been extremely gracious and helpful. So I don't think we have a bad deal here, but I have no disagreement with the opinions that have been leveled. And of course, Christy and Brian are ready to go.
I agree with everything that's been said, and I think we've got a lot of good people. Rob, I agree with what you said about CJ. Tom, I think that's a good slate if that's where you are.
I think Debbie was going to say something.
I beg your pardon?
I said I think Debbie was going to say
something.
I'm
sorry.
Before you wrap.
That's okay. I was just going to tell you my top three have been Brian, Timothy, and Christy as well. Before you even started talking, those were my three choices.
Where I was going was everything having been said, I think we owe it to the governor perhaps to send the minimum number that the statute requires, and that's 3 people. So sounds like that's what everybody is thinking anyway.
Well, and I think that one of the candidates indicated that we probably got a couple of openings coming up in the next 3 to 4 years, somewhere in there, and Chris has only been in his position as a magistrate for 2 years. I think 3 or 4 more years down the road, whatever that thing takes, will give him additional experience. I think the same way Ed has been at Scott City for about 5 years, and whenever those openings come up with whichever judges decide to retire, whatever, I think both of these magistrates will have more opportunity for more experience. So that would kind of be my thought.
I'm gathering that's a motion.
I would move that we send a slate of Brian Sherwood, Tim Woods, and Christy Cott on to the governor for selection for district or for district judge.
I'll second.
I'm muted. For the motion and the second, then we can do a roll call vote, or we can just raise your hand on the screen. Other than Ann, we got to know where Ann is in the deal.
That can be, yeah, we're together.
So,
Hello, Ann.
Ann's here.
Hey, who's that guy behind you?
what do y'all just want to raise your hands on this one?
Sure.
Yeah.
All right, all in favor. We've got a slate of candidates.
Shelby, raise your hand.
I guarantee you she's got an opinion. Here's the question I have, because and Bill, I'll defer to you, but since you're not in your office, and assuming everyone else would agree, can we have Shelby send an email to all of the applicants and say that these three are the nominees going to the governor? Or, I mean, or you can do it later. I was just trying to get the word out, and you're not in your office right now. So
I think having Shelby do it is just fine.
thank you, because you've already got those all loaded up in your computer.
Yeah.
Otherwise I'd do it, but I haven't emailed all of these people. So we will do that. Is there any other business to take up to the commission? I see nothing. Thank you all very much for your time. This is always difficult to do online and a little tiring, a little more tiring, I think. But I think we did a good job of vetting the candidates. So I appreciate your service.
Well, Justice, the only thing I see lacking is to keep John happy. We got to find some way to feed him.
I'm gonna keep the apple that I have now for the next one.
Justice Biles authorized me to spend 50 cents, so I got 2 of these. Eat one, and we'll eat the other one here in a minute.
Well, we can take that out of our out of the treasury for the commission.
We used to call that the slush fund back in the day.
All right. Thank you.
Thank you, guys.
Thank you all very much.
Thank you.
Be well, everybody.
Thank you, Shelby.
Thank you.
Don't lose that.
Hey, Shelby,
Yes.
have you stopped? Just go to the 3 dots